originating application 451 of 2022, Hodlnaut Pte Ltd.
All right, thank you. Good morning. Let me administer the Zoom allocation first. So parties are reminded there should be no unauthorized photography or recording in any form, and no dissemination of any photographs or recording of these proceedings. And only those counsel persons notified to the court should be present in each location, and parties should treat these proceedings as they would a physical hearing. Right, for the applicants, Hodlnaut Pte Ltd, Ms. Ning Jie, Mr. Darius Lim, and Mr. Keith Lim, correct?
Yes, Your Honor.
All right, thank you. For the IGMs, Mr. I know Leo. Oh, you're alone this morning, Mr. Leo, correct?
I'm sorry, Your Honor. We have a number of people in the room with me, Your Honor. If I could just introduce all my colleagues.
All right, yes.
I'm grateful, Your Honor. Your Honor, Lionel Leo from Wong Partnership. I appear together with my colleagues, Mr. Manoj Sanchosegara,
Right.
Ms. Stephanie Yeo,
Right.
Mr. Muhammad Nur E. Adnan, Mr. Andrew Fluke, Ms. Clarice Chung, Ms. T. Abirami, Ms. Alicia Lim,
All right.
and with Your Honor's leave, intern of our firm, Ms. Andrea Fong.
All right. All right, they're all in the same room with you.
Yes, Your Honor. I believe Mr. Fluke has dialed in separately, but he's also in the same room. We've had him dialed in separately in the event any documents need to be shared screen with Your Honor.
All right, thank you, Mr. Leo. So what I'll ask you to do is, could you confirm the list of my manager later? All right.
Yes,
Thank
Your Honor, we will do that.
you. Thank you. And for the non-parties, I believe Mr. Junta, Mr. Fabian Kang, correct?
May I please, Your Honor? Yes.
All right, thank you. For Mr. Simon Lee, Mr. Randall Pereira, correct?
That's correct, Your Honor.
All right, thank you. For SAM FinTech, Mr. Patrick Ang and Ms. Raylene Pereira, correct? All right. Sorry, I see Ms. Pereira. Sorry,
Yes,
yes.
Your Honor.
Are you with Mr. Patrick Ang or is he absent today?
Your Honor, he is with me in the same room.
Oh, in the same room. All right, thank you. All right, and for Algaran Foundation, Mr. Daniel Chan.
That's correct, Your Honor. And I have my colleague, Mr. Levin Low, with me in the same room.
All right, thank you. For Mr. Chen Yuan Si, Ms. Dorothy Tan.
Yes, Your Honor.
Okay, thank you. For the Attorney General, Ms. Olivia Low and Mr. Clement Lim.
Yes, Your Honor.
All right, thank you. All right, we have a number of matters, but let me just check the courtroom and everything else first. All right, thank you. All right, now let me try to sort things out. We have a number of applications. I'll come to the JM application subsequently, but perhaps at this point it would be good for me to have Mr. Leo summarize the IGM's position, and I'll turn to the applicants thereafter. Mr. Leo?
Thank you, Your Honor. May it please the court. Your Honor, perhaps before I go into our submissions, a summary of our submissions for summons 3660 of 2022, Your Honor, just as a matter of housekeeping, I just wanted to update Your Honor on two letters that we had sent to the Honourable Court on the 11th and 12th of January 2023, Your Honor.
Yes.
Your Honor, I hope I'm not jumping the gun a little, but our letter on the 11th of January 2023, Your Honor, we wrote in to update Your Honor on the positions taken on the judicial management hearing by some of the largest creditors of the company.
Mm-hmm.
Your Honor, just to summarize, because my colleague Ms. Yeo will be doing the submissions for OA 451 of 2022 with Your Honor's leave.
Yes.
The positions taken, Your Honor, and I think my learned friends from Raja and Tan and Mr. Chan for Algaran will confirm that. For Samtrade Custodian Limited and Samtrade FinTech Limited, Your Honor, the position taken by Samtrade is that the company should be liquidated, in particular because they do not have any trust that the directors are the right people to continue to manage the assets of the company in the alternative restructuring plan that was put forth or their original restructuring plan. But their position, I believe, is that they do not support summons 3660 for the removal of the IGMs, and they are content for the IGMs to be appointed judicial managers for the sole purpose of putting the company into liquidation. I believe that's the position for Sam Trade Custodian, and we had wrote in to update the court on that. Your Honor, for Algaran, who is the second largest creditor, if on a group level, Your Honor, because as Your Honor will appreciate, continues to be some uncertainty as to the distinction whether it is all the assets of the company should be divided into Singapore entity and Hong Kong entity or a single entity. But Algaran's position, I think it's similar to that of Sam Trade, Your Honor. Their position is that because they have no trust in the directors to continue to manage the assets of the company, notwithstanding the safeguards that have been proposed in the alternative restructuring plan, they also take the position that the company should be liquidated. And I believe that their position is similar, that there is no basis for summons 3660, and they are content for the IGMs to be the party putting the company into liquidation. So that's what I wanted to update Your Honor on our letter of 11 January 2023. And Your Honor, on our letter of 12 January 2023, Your Honor, we had wrote in to update Your Honor on the discussions that the parties in relation to summons 4010 of 2022 had been having. As we had previously updated, Your Honor, the parties are trying to amicably resolve the issues, and there has been progress. An affidavit has been filed by Mr. Simon Lee. And I think for Mr. Daniel Lee, he has given the IGMs everything that we had requested for. We have custody of the laptop, his laptop. We have managed to gain access to it. So we will not be progressing with summons 4010 as against Mr. Daniel Lee. But Your Honor, for summons 4010 as against Mr. Simon Lee, there remain certain outstanding issues. But given the progress, and we are hopeful that we can reach an amicable resolution, we were going to seek an adjournment of summons 4010. My learned friend who act for Mr. Simon Lee, Mr. Kang, I think when we had raised this with him yesterday, did not yet have instructions. So I perhaps would, I don't know whether Your Honor wants to hear from Mr. Kang on his position before I move on to summons 3660.
Can you hear me?
Yes, Your Honor, now we can. I'm sorry.
All right, sorry. So I was going to stop you just now. Annie, can you check the audio, please?
Yes.
Right. So for the moment, Mr. Pereira, you're acting for Mr. Simon Lee, correct?
That's correct, Your Honor.
All right, sorry. Thank you. All right. So let me just confirm this. 3660 we'll deal with in a short while. But for 4010, Mr. Leo, you are proceeding or you asking for adjournment in relation to Mr. Simon Lee, but not proceeding against Mr. Daniel Lee, correct?
Yes, Your Honor.
All right. All right. Thank you. All right. Can you summarize the position of the IGMs based on their work in the last few months at this point?
Yes, Your Honor. Your Honor, as I had mentioned earlier, in terms of the work of the IGMs, I think that was something my colleague Ms. Yeo was going to submit on. Would Your Honor be happy for Ms. Yeo to bring Your Honor through that?
Yes, please. Thank you.
Thank you, Your Honor.
Good morning, Your Honor. I'm Stephanie Yeo for the IGMs. To summarize the work that the IGMs have done during the IGM period, so basically, Your Honor, the IGMs have attempted to secure all the financial information concerning the company and concerning the company's financial assets in order to put together an accurate and complete picture of the company's financial position. Unfortunately, I think there were some difficulties in obtaining some of the financial information, as some of the records were not adequately kept by the company. So there was some difficulty there. Part of the reason stemmed from documents which were deleted from some of the company's workspaces, which was why summons 4010 was brought. Aside from that, the IGMs have also attempted to secure all the financial assets that clearly belong to the company. So these concern the cryptocurrency assets that are held with certain centralized exchanges. And the IGMs have, I think, they've completed the process of transferring the assets that are held in the centralized exchanges to co-wallets that are now in the IGM's possession. There is also the issue of the transactions between the Hodlnaut Singapore and Hodlnaut Hong Kong. And to that end, the IGMs have also been taking legal advice from Hong Kong Council as to how to deal with Hodlnaut Hong Kong, as well as trying to figure out the distinction between Hodlnaut Hong Kong creditors and Hodlnaut Singapore creditors for that purpose. As of this date, the IGMs have not reached a firm position on which creditors are Hodlnaut Hong Kong's creditors and which creditors are Hodlnaut Singapore creditors. From what I understand, the position is not quite so clear, and at the appropriate stage, directions may need to be sought from the court concerning this issue. The last point, which the IGMs have been working on, was the alternative restructuring plan, which the IGMs had presented to the creditors. I would go into a little bit into why this alternative restructuring plan came about, but I'm not sure if Your Honour wants to hear that now or.
You can just summarize at this point, please.
Yes, Your Honour. So notwithstanding the financial difficulties of the company, the lack of financial information regarding the company, the IGMs considered that in any restructuring, time is of the essence, and given that at the hearing of the GM application, the IGMs would be required to update the court on whether they are of the view that the purposes of GM could be met by GM order. As such, it was necessary to progress the discussions on the restructuring plan in parallel with its efforts to secure the financial records and information of the company. So, when reviewing the restructuring plan that was proposed by the directors concerning the potential restructuring, the IGMs considered that there were certain fundamental matters that were not addressed by the plan. So, for example, given that the company's balance sheet was solvent, the restructuring plan that was proposed by the directors did not deal with the balance sheet insolvency of the company. In addition, the restructuring plan did not provide the creditors with any assurance that if they supported the plan, they would end up in a better position than liquidation. Therefore, the intention of the potential alternative restructuring plan was conceptualized in order to attempt to address some of the key shortfalls that we saw in the restructuring plan, so that we could present a more holistic view to creditors as to what the structure of a proper restructuring plan could look like, as opposed to. Your Honour, I'm not sure if you can hear me, but you appear to have dropped off.
All right, Ms. Yeo, can you hear me now?
Yes.
All right, sorry, please carry on. Sorry, thank you.
Your Honour, no problem. I wasn't sure where you dropped off.
Just proceed from the conceptualization of the plan. Thank you.
Yes, Your Honour. So we had conceptualized the plan, as I was mentioning earlier, to attempt to address some of these key fundamental shortfalls that we saw in the initial restructuring plan that the directors had proposed. So the intention was really to present a more holistic picture to creditors on what the structure of a proper restructuring plan could look like. And it wasn't to present a fully fledged scheme of arrangement to the creditors. And the purpose was so that the creditors could apply their minds to the key issue of whether they were prepared to support a rehabilitation or a recovery of the company's business. So that was really the intention behind the alternative restructuring plan. And it was actually conceptualized before the news of the CAD investigation into the directors broke. So, it wasn't a case where IGM saw that there was the investigation and still proceeded to try to conceptualize a restructuring plan. As I understand, this is a particular issue that a lot of the creditors have concerns with. So that was just a work stream for the restructuring plan. And finally, the last work stream that the IGMs have been working on is that in relation to OA 395, which is the judicial review proceedings. So as of this hearing, a disposal hearing has been fixed for February. So next month, I believe it's 9th of February, where the court will determine who should have ownership of some of the cryptocurrency assets that were seized by these Singapore police force.
All right. All right. Anything else, Ms. Yeo?
No, Your Honor. So this would be a summary of the work that was done by the IGMs.
All right. In terms of the status of the company, any concerns? Or rather perhaps not the status, but the pre-JM affairs of the company. Were there any concerns? Would you like to summarize the IGM's position, please?
Yes, Your Honor. So the IGMs do have some concerns as to how the affairs were conducted pre-IGM. However, given that the IGMs were appointed for the purposes of preserving the assets, the IGMs considered that it was not within their mandate as circumscribed by the court to go into a full-fledged investigation into the conduct of the directors prior to the IGM period at this point. However, what they did focus their efforts on was to preserve whatever evidence that they could, so that insofar as a liquidator or judicial manager subsequently is minded to investigate the conduct of the directors prior to the IGM period, then this could be done.
All right. All right, then. At this point, then, let me turn to Mr. Randall Pereira from Mr. Lee. I received a letter from you, Mr. Pereira, highlighting the discussions to date. So what has been described by Mr. Leo would be accurate, that there are ongoing discussions?
In relation to summons of 4010,
Yes.
Your Honor, that is correct. I think we share belief that it's not necessary to trouble Your Honor with the whole host of issues. It probably can be resolved.
All right, thank you. All right, thank you for that. Let me then put that out of play this morning. So I will then adjourn summons 4010. How long do you think you'll need, Mr. Pereira, to sort things out?
Your Honor, I think some of it depends, I think, on the CAD, because I think some documents are with them. And insofar as they've asked for, my learned friends asked for a privilege list, I would need to see the documents, so that has to be released.
So what would you estimate it to be?
I suppose then in that case, I would ask Your Honor for a slightly longer timeline, perhaps 4 weeks.
4 weeks. All right. Mr. Leo, adjournment of 4 weeks, would that be in order?
Yes, Your Honor, I think that's in order. Your Honor, I was going to also say that in terms of the order sought, if a judicial management order is made for the sole purpose of putting the company to liquidation, I think it would take about 2 months for the IGMs, if later appointed JMs, to have that done. So
right.
4 weeks, I think, is quite fair, Your Honor.
All right. Well, that will be a different matter, which I'll have to hear out the applicants and some of the other parties as well. But for the moment, then I'll adjourn summons 4010, 4 weeks. If anything comes up of the other applications later affecting this, we'll deal with that again later. All right, so that's 4010. All right, summons 3660. Hold on. Let me see. Mr. Randall Pereira, that's your application, correct?
Yes, Your Honor.
All right, you're still proceeding with that?
Yes, Your Honor. I accept. I think that today the hearing is also there are 2 hearings. One is for removal of the IGMs, and one is for the JM's appointment.
Yes, so that's why I was wondering whether we're still proceeding with this.
I would, with Your Honor's leave, ask to make submissions on the core thrust of 3660 in any event. I think there's a duality to the submissions. One is, even if I don't hit the higher threshold of removal of the interim judicial managers, I think a lot of these issues that have been raised, I think, go to the heart of Your Honor's decision in choosing the candidate for the insolvency petition.
What I propose to do then is I'll take the arguments for 3660 together with 451. At least in your respect. All right. I think that'll make it more efficient then. All right. let me just record this from Mr. Simon Neely to be taken with OA451. So in that case, then what I propose is to proceed to OA451, which is for the appointment of the JMs, because once that is done, that will effectively deal with the question of the IJMs. And if Mr. Pereira's client makes out his case for the removal of the IJMs, I will record that along the way, although I think in practical terms, it will be superseded by the appointment of the JMs, whoever they may be. But I'll take Mr. Randall Pereira's arguments into consideration when I decide the relevant appointments under 451. All right, so comfortable with that, Mr. Pereira?
Yes, Your Honor. Great.
All right, Mr. Leo?
Yes, Your Honor.
All right. All right. Sorry, before we proceed, Mr. Leo, did you send in written submissions for 450? Sorry, 451?
Yes, Your Honor, but this would be the previous round because I think there were no directions for fresh written submissions.
All right, so you're sticking with that. You haven't submitted anything new, right?
Yes, Your Honor. I think neither party have. So we'll be relying on our written submissions dated 14th of November 2022.
You are relying on that. Wait, hold on, but I have a new set of written submissions from Mr. Or rather Ms. Ning Jie's side dated 6th January 2023. You have a copy of that, Mr. Leo?
Yes, Your Honor. I think that would be in the context of OA451, Your Honor. But for summons 3660, there's no further written submissions.
So I'm asking you in relation for the 451. Do you have anything new?
No, Your Honor. We didn't put any new submissions.
You didn't put anything new. All right, thank you. I just wanted to confirm that. All right, thank
you. Yes, Your Honor.
All right. Can I then check in to see who's making arguments on 451? So Ms. Ning Jie, I assume, Mr. Leo, Mr. Pereira. Mr. Kang, are you making any arguments on 451?
No, Your Honor. No, it's unlikely. I'll be aligning my position with Mr. Pereira. However, I may seek Your Honor's indulgence to make some very brief remarks if necessary.
All right then. All right. So I'll remember to come to you, Mr. Ang and Ms. Pereira for Sam FinTech. I assume you are correct.
Your Honor, we will not be making arguments, but I just need about 5 minutes to summarize my client's position.
All right, summary of position rather than arguments. All right. Algaran, similarly, I think Mr. Daniel Chan.
Your Honor, that's correct. No legal submission or no arguments rather, but we have certain positions which
all right.
Will be
all right, and Ms. Low. Ms. Low, I assume you're just on watching brief, right?
Yes, we are watching brief. And we don't have any submissions to make. We may only need to respond should there be any allegations in relation to counsel, state counsel.
All right, certainly. All right, thank you. All right, in that case then, Ms. Ning Jie, can we start with you first and then we'll go down the list with everyone else.
Very well, Your Honor.
Thank you.
In OA 451 of 2022, the applicant company Hodlnaut Pte Ltd applies for an order that the company be placed in judicial management and for the appointment of the company's nominee, Mr. Tan Chi Chung of Carols Corporate Advisory Private Limited, as judicial manager of the company. The applicant maintains this position today.
Yes.
Just by way of procedural background very quickly, in the IGM application, Your Honor has appointed the current IGMs from EY Corporate Advisors Private Limited, who are nominated by Algoran Foundation Limited, one of the non-parties which have stated that they are creditors of the company subject to adjudication. The current IGMs were appointed to avoid, as best as possible, any concerns about independence, rather than out of concern about the expertise or competence of the nominee proposed. For the factual background relating to the company and its business, we have previously provided this in the company's written submissions for the IGM application. Just to recap, Your Honor, the applicant is a Singapore registered company. It has 2 wholly owned subsidiaries, one registered in Hong Kong and one in BVI. The subsidiary in BVI is dormant, and the company was established to set up a platform on which users can deposit digital tokens and be paid an interest. The company then, among others, lends these tokens to earn interest. So the company doesn't hold property or assets on behalf of its users. Any tokens deposited by a user would be recorded as a liability owned to the user by the company or by the relevant entity, whether the Hong Kong subsidiary or the company itself. The detailed business model of the company is further elaborated in the first affidavit of Zhu Jingtao, which is in tab 1 of our bundle of documents, and I shall not go into the details of it. I'll go direct into the application for judicial management today. The law relating to the making of a judicial management order is not controversial. In short, there are two conditions which both have to be satisfied. The first is that the company is or is likely to be unable to pay its debts. And second is that the making of the order will likely achieve one or more of the statutory purposes of judicial management. They are the survival of the company or the whole or part of its undertaking as going concern, the approval of a compromise or arrangement under the relevant provisions, or a more advantageous realization of the company's assets or property than a winding up. I'll elaborate how the applicant company is able to satisfy both conditions. The first condition, the company is or is likely to be unable to pay its debts. In the first supporting affidavit of Mr. Zhu Jingtao, the applicant has set out that in May 2022, the digital token USTC lost its ability to maintain its peg to $1 and collapsed to almost zero in value. So this caused a loss to Hodlnaut Hong Kong in the amount of approximately $190 million. And this led to Hong Kong's inability to repay the liability owed to the applicant company. On the group level, the total debt as at 13th May 2022 was approximately $500 million and backed by realizable assets of about $315 million. In June and July 2022, with a decline in the asset prices of cryptocurrencies such as Bitcoin and Ethereum, there were greater than euro outflows and leading to a greater mismatch between the assets and liabilities on the group level. And at the same time, the company faced seizure orders from the CAD, which the company took up an application for permission to commence judicial review. For completeness, the proceedings have subsequently been resolved amicably with the CAD under the management of the IGMs. So on 8 August 2022, the Hodlnaut Group halted all withdrawals and deposits on its platform when the group's cryptocurrency asset to debt ratio was approximately 0.31. So as stated in our written submissions for the IGM application, as at 19th August 2022, the applicant was likely to become unable to pay its debts. Subsequently, on 3rd October 2022, based on the statement of affairs submitted by the directors of the company, as summarized by the IGMs in their first report, the total realizable assets of the company is approximately SGD 60,000, while the total estimated liability of the company are approximately SGD 273,000. The IGMs in their reports have also provided an overview of the group's consolidated estimated assets and liabilities. Based on the IGM's second report, the total estimated value of the group's asset was approximately SGD 83,000, while the total liabilities were approximately SGD 349,000. In the circumstances, we submit that the present situation is one where the company is likely to become unable to pay its debts, if not already unable to do so at present. That's for the first condition. For the second condition, the making of the order will likely achieve one or more of the statutory purposes of GM. When considering an application for judicial management order under the Companies Act, the Honorable Court of Appeal in Deutsche Bank held that where the company is clearly insolvent, the question is one of whether or not there's a real prospect that the appointment of judicial managers will achieve one or more of the purposes stated. And Your Honor, we say that because the other provisions here and the predecessor provisions under the Companies Act are parent material, the principles and law governing the latter should continue to be applicable. Yes, Your Honor. And the applicant submits that it has a real prospect of achieving one or more purposes of judicial management. I'll highlight a few key reasons. First, there is a business recovery plan previously proposed by the directors. Apart from the Terra USD crash in May 2022, the group's business has been profitable since its inception in 2019. The company's evidence is that since its inception in 2019, the group's assets base grew at 20% per month, on a month-to-month basis up to March 2022, peaking at USD 750 million. And the group's gross profit margin was approximately 7 to 10% for the past 18 months. It is likely that based on the track record, the group and/or the judicial manager is able to execute a suitable business discovery plan. And this will likely allow the survival of the company or the whole or part of its undertaking as a going concern. And this may lead to approval of a compromise or arrangement under the relevant provisions. And if not, at least a more advantageous realization of the assets or properties that are winding up. The IGMs in their second report indicated that the IGMs have proposed an alternative restructuring plan, which my learned friend mentioned just now. And the IGM's view is that the alternative restructuring plan could provide a more holistic solution to the group's financial position as compared to the initial iteration of the business recovery plan. We note that based on the letter from one partnership that my learned friend has brought Your Honor through just now, the IGMs have had discussions with some of the 5 of the largest creditors of the group and/or the company, subject to adjudication and excluding the directors or entities controlled by the directors. And the 3 parties named in the other hearing-related requests have the common view that the alternative restructuring plan proposed by the IGMs would not be feasible, as the directors are not the right parties to be managing the company's assets. And their views are that the company should be placed into liquidation. Our response is that we know this is a view expressed to be shared by 3 creditors of the group and/or the company. They have now filed an affidavit setting out this position, and there's no indication of how many percentage in value of the total liability of the company that the 3 creditors hold. So our submission is that their position does not necessarily represent the view of the majority of the creditors of the company. And further, Your Honor, the objection of the 3 creditors, as summarized by the IGMs in the letter to court, is that the directors are not the right persons to be managing the company's assets. We say that this concern can be addressed in the case of judicial management, where the judicial manager will take over the function and management powers of the directors, just like the current situation of IGM. This suggests that the tweaking of the proposal might be necessary, but that creditors may be willing to consider business plans if their concerns are addressed. And we say that there remains a real prospect of achieving 3, if not at least one of the purposes of judicial management. And Your Honor, lastly, a winding up of the company and the resulting liquidation of the cryptocurrencies at present prices would be commercially insensible. The company's evidence is that the cryptocurrencies are currently severely undervalued, especially Bitcoin and Ethereum, and that there are strong upcoming catalysts which will likely lead to an appreciation in the prices of BTC in the next 2 years.
Sorry, what will lead to an increase in the value of cryptos in the next 2 years?
So the company's evidence is that there are strong upcoming catalysts which will likely lead to appreciation of the prices. Yes, if I may summarize the evidence, there will be further adoption of certain cryptocurrencies such as Bitcoin. And based on analysis of the trends of the variation of the prices, the company's evidence is that the company's belief is it will likely increase in the next 2 years.
All right. Thank you. Carry on, please.
Yes, Your Honor. The IGMs in their second report indicated that the IGMs have converted all of the remaining altcoins held on certain centralized exchanges to BTC to mitigate volatility risks. This means that an appreciation of the value of BTC would improve the company's financial position. And we say that this shows that there is a real prospect that the judicial management could at least lead to a more advantageous realization of the company's assets or property than a winding up. And Your Honor, we submit that these reasons show a real prospect that one or more of the purposes of judicial management can be achieved. And we fall back to our written submissions. We have elaborated where we have elaborated on those reasons. And in the circumstances, the company maintains its nomination of Mr. Tan Chi Chung. And I'll run off my submissions by saying that the applicant's position is that this is an appropriate case for judicial management order to be made and for Mr. Tan to be appointed as judicial manager.
All right. Could I confirm, does the company have any concerns about the IGMs as such, being if they were to be appointed as permanent GMs?
Your Honor, we don't have instructions specifically in relation to this, but we'll just say that we're not taking any positions in any of the interlocutory applications, including summons 3660.
And your preference for Mr. Tam would be for the reasons you had previously adopted, right?
Your Honor. Yes, Your Honor.
All right.
I don't have anything further unless Your Honor has any questions.
All right, thank you.
Thank you.
All right, let me turn then to Mr. Leo for the IGMs.
Yes, Your Honor. Your Honor, perhaps I would just touch briefly on the submissions on 08451 because I presume for summons 3660, I should wait for my learned friend, Mr. Pereira, submissions and respond to that.
All right. Yes.
Yes, Your Honor. My colleague, Ms. Yeo, has already brought Your Honor through the alternative restructuring plan. I just thought we probably don't need to make too many submissions. We just wanted to point out, Your Honor, that I think in terms of my learned friend had talked about the percentage of the debt, unsecured debt. I think we have some numbers. We don't have it on affidavit, Your Honor, but I just thought it may assist, Your Honor, that in terms of the creditors that I had brought Your Honor through who had written into court, that Sam Trade Custodian, as well as the related entity, Sam FinTech, as well as Oilground Foundation. I think the total amount, the percentage of the unsecured debt is about 45%, Your Honor, of the company's unsecured debt. And in terms of the opposition to the judicial management order being made for the rehabilitation of the company, as opposed to for the company to be put into liquidation, I think we will simply submit, Your Honor, that it appears that there has been no support, not just from the three largest creditors of the group, but no other creditor has, I think apart from perhaps the directors who are also creditors, have expressed support for any of the restructuring plans, be it the original plan that was put forth by the directors while they were in charge of Hodlnaut, or for the alternative restructuring plan that has been put forth by the IGMs, Your Honor. So I think that is the position. As for the IGMs, we are not taking an affirmative position on what is the proper cause. But Your Honor may be aware that for the Sam Trade case, what the order that was made was a judicial management order for a short period of time for the then IGMs who were then appointed judicial managers to put the company into liquidation. The only thing we would raise, Your Honor, is whether the more appropriate order might be for a continuation of the interim judicial management order, simply because if Your Honour is of the view that none of the purposes of judicial management can be fulfilled, be it the company being allowed to continue as a going concern, the putting in of a scheme, or for more advantageous realization than liquidation, then perhaps, Your Honour, the more appropriate order is to allow the IJMs to continue in their role as IJMs and then to put the company into liquidation on that basis. That really was our submission on OE. Yes.
All right. So I think one of my concerns is really trying to see what the likelihood of rehabilitation will be or the advantages winding up. I appreciate what has been laid out, and I will of course hear out the positions of the Semfintech and Algorand. But would it be accurate for me to say at this point the IGMs do not actually think that it's not impossible or not improbable that there could be some better realization on liquidation or some effort made to try to keep it an ongoing concern, that the company could possibly survive? I'm just trying to figure out what is the level of assessment of success in terms of either trying to get the company to continue or to have a better winding up.
Yes, Your Honour, I understand. I think, Your Honour, in terms of the IGM's position on this, my colleague Ms. Yeo will address, Your Honour, because as I mentioned, that was the way we had divided the labour for this hearing, Your Honour. And she had some further points.
Yes, Ms. Yeo.
Your Honour, I think to sum up the IGM's view on the application, I think we take the view that the statutory purposes of the JM order appears unlikely to be achievable in this case. Maybe I can sort of take Your Honour to the broad points as to why we have taken this view. As mentioned in our letter, I think quite a number, well, 4 out of 5 of the largest creditors of the group have taken the view that they do not trust the directors to continue managing the assets of the company. And while I appreciate learned counsel from appearing for the applicant's point that the judicial manager will take control of the company's assets, it must be remembered that judicial management cannot be a permanent state of affairs. At the end of the day, the JM order must be discharged and the company would then have to be returned to the directors. So fundamentally, if the creditors are not comfortable with having the directors continue to helm the company, then judicial management would simply be kicking the can down the road. While I also do take a point that the number of creditors surveyed in terms of their value and the percentage of their debt held, it does not necessarily represent the majority in value and let alone the majority in number of the creditors. It also remains true that there are no other creditors who appear to be actively supporting this JM application. Further points in that that we also have is, firstly, while we have considered the possibility of having the director step aside and appointing a third-party fund manager. However, we were of the view that this would not be feasible, given that it would come with certain amount of costs, and insofar as creditors would require a certain assurance of a better return if they stick with the judicial management instead of going for a liquidation. It is unlikely that any third-party fund manager would be prepared to guarantee any form of returns to the creditors such that they would receive a better return in judicial management as compared to a liquidation. I also would like to point out that 2 out of the 3 major creditors have taken the view that due to the poor market outlook of the cryptocurrency as well as the huge losses sustained by the company, these constitute insurmountable impediments to the rehabilitation or recovery of the company. One of which I believe is Algorand, who is currently in the business of in the cryptocurrency, very active in the cryptocurrency space as well. So, Your Honour, I do believe that the views of Algorand should not be discounted. Thirdly, our view is that it is unlikely that there will be any external interest in the business of the company. Your Honour, in this case, the company's business is different from a typical business that we normally see in restructuring, where there could be valuable counterparty contracts or networks that could be preserved by acquiring the business as a whole. Rather, the company's value in this case is only in its portfolio of assets, which, to be honest, could be acquired separately and perhaps even on a piecemeal basis. So in the circumstances, we do think that it seems very unlikely that the first two purposes, meaning mainly the survival of the company or part of its undertaking as a going concern, as well as the approval of a scheme of compromise, a scheme of arrangement or compromise, would likely to be achievable in this case.
Right.
As for the third statutory purpose, which is a more advantageous realization of the company's assets, our view is that there does not appear to be any significant benefit in realizing the assets in judicial management as compared to a liquidation. Firstly, there is nothing preventing a third-party investor from acquiring the portfolio of assets held by the company in a liquidation. The liquidators also have the necessary powers to conduct a sale by auction, if necessary, to obtain the most competitive price, as is currently being done in some of the Chapter 11 bankruptcies of cryptocurrency platforms in the US. Secondly, the making of a liquidation order does not mean that all of the cryptocurrency assets have to be immediately liquidated and converted into fiat currency. There is nothing preventing the liquidators from undertaking a managed wind down of the company and converting the assets to fiat currency at a sensible point of time. In the fiat currency world, Your Honor, I would just like to point out that funds that are being liquidated often undertake such managed wind downs so as to provide more competitive returns to the investors. So there's really nothing preventing the liquidators, if appointed in this case, at the appropriate point in time to undertake such a managed wind down.
Sorry, could I stop you there, Monsieur? Is this really all in your client's affidavit?
No, Your Honor, this is not in our client's affidavit. Right. Unfortunately, we would have preferred to put this in an affidavit. Unfortunately, due to the development in circumstances where the creditors gave us their perspectives on the alternative restructuring plan, and as that came in a week ago, we were not able to put in a lot of this into an affidavit.
All right.
Final point, Your Honor. I just wanted to point out that in this case, almost all of the employees of the company have since resigned. So it is not a case where judicial management will be able to preserve the employment of the employees in this case.
All right. I have some difficulties here. I would actually like some of these things to be on affidavit because I will need to decide some matters, exercise my discretion on the basis of the record. So I'll give directions for this. And
sorry, yes. If I could just offer a suggestion.
Yes.
Your Honor, as my colleague had pointed out, if the company is to go into liquidation, there are two possible procedures for which the company could proceed into liquidation. The first is to make a GM order specifically for the purpose of liquidation. The second, Your Honor, is to extend the IGM period for the purposes of filing for liquidation, fix a date for the hearing of the winding up application, and adjourn the GM hearing to the same date so that the GM application can be considered concurrently with the liquidation application.
Well, certainly that's one option. I have some reservations about doing that at this point, but I'll bear that in mind. So I want to basically express the fact that I think certain things have to be put on the affidavit by your clients, but also turning back to Ms. Ning Jie. Ms. Ning, unless I'm mistaken, there hasn't been an affidavit from Mr. Tam, correct? Giving his views on the latest developments. Sorry?
Yes, sorry, Your Honor.
Would you know whether Mr. Tam might be willing to do so? Basically, what I would like to know is whether your nominee has any different views about how things might pan out. Do you think that's something you could bring in?
Your Honor, subject to instructions, I believe that that's something we could try.
All right. So bear that in mind. All right. So let me turn from the IGMs then to the others. And I understand Mr. Merkin in the public gallery would like to speak later as well. But let me then go through quickly. Mr. Kang, do you want to state any position on this at this time? Sorry, Mr. Kang?
No, Your Honor, I apologize. No,
Nothing. All right. I'll come back to Mr. Pereira later. Mr. or Ms. Pereira for Sam FinTech? Or Mr. Patrick Ang?
Yes, Your Honor.
Mhm.
Your Honor, I believe Mr. Leo has accurately summarized my client's position in terms of the JM application before the court. Essentially, the Samtrade companies have no confidence in the directors of Hodlnaut. And given that the involvement of the directors in the ARP is an essential plank of the plan, we really feel that the proposal is not feasible. And the company should be put into judicial management for the purposes of placing it in liquidation. We also support the appointment of the IGMs, SGMs for the eventual purpose of putting the company into liquidation.
All right.
Your Honor, there's a whole host of reasons that my clients have set out in their letter to IGMs, explaining their reasons for the position that they've taken. I think most of them align with the submissions that Ms. Yeo has made today, so I will not take Your Honor through those unless Your Honor requires me to. What I will perhaps add, in addition to the points that Ms. Yeo has raised, one specific point in particular, the principal reasons for my client's objections to the company continuing in JM, other than for the purpose of putting it into liquidation, is not just the involvement of the directors. If we were to consider the business proposal that was put forward by the company, as well as the ARP that was outlined by the IGMs, neither plan involves a plan for the fresh injection of funds. So what would essentially happen if the company were to be put into JM for the purpose of trying to achieve one of the objectives, is that the JMs would have to utilize the available assets in the company in order to try and achieve one of the statutory purposes, which would eventually run down the available assets for distribution to the creditors.
All right, thank you.
Thank you,
Anything
Your Honor.
else?
Yes, if I could just briefly address one more point that my learned friends from Wong Partnership have made, and that's in connection with how the company could be put into liquidation. As Mr. Leo had mentioned earlier, we had suggested that the company be put into judicial management for the purpose of placing it into liquidation, but he had also raised another suggestion, which was to extend the interim judicial management order so that the IGMs could make the application to court to wind up the company. I'd just like to state that we have no objections to either approach. To give Your Honor a bit more context as to why the approach of making the GM order was made or taken in the case of Samtrade, as Mr. Leo alluded to, that was essentially because in Samtrade's case, the court had decided to exercise its discretion, I believe under section 91, subsection 10, to make the judicial management order on the basis that the public interest so requires. That was essentially why the GM order was made, for the purpose of liquidating the company.
All right, thank you. Anything else, Ms. Pereira?
Nothing further, Your Honor.
All right, thank you. Mr. Chan for Algaran?
Yes, Your Honor. Grateful for that. Your Honor, my client's position is that we want the company to be liquidated as soon as possible. Whether that is done via an extension of the existing IGM order for a winding up application to be submitted to the court, or where the company is put into judicial management now, with a view to having it wound up in the next 2 months or so. We are fine with either approach, and they both, I mean, appear to us to be workable. As to the possibility of restructuring, for the reasons already outlined, my clients think that there's no realistic prospect of the company being rehabilitated. Allow me to elaborate a little. Your Honor, this is a company which essentially was taking monies, promising certain returns, and using the monies that were deposited to trade. And through those trades, they hope to make sufficient profits for themselves and for to pay out the returns to those depositors. The restructuring plan or the business recovery plan was essentially for the directors to trade themselves out of trouble using their existing assets without any new injection of funds. And while the alternative restructuring plan contained certain mechanisms for oversight, essentially it was still going to be reliant on the directors trading themselves using their existing pool of assets with no fresh injection to try to make a profit that would, be able to cover up the losses that they have suffered over the past year.
All right.
That seems unrealistic to us in light of the current status of the cryptocurrency market. And it's also inconceivable to my clients that the directors should continue to have any role in the management of assets, given that they're now under investigation by CAD for fraud and cheating offences. So just to echo the point made by Ms. Pereira, I think they've lost all confidence in the directors. And we can't see, we won't support any rehabilitation that has them continuing to trade.
All right, thank you. Anything else, Mr. Chan?
I think nothing further to add structurally.
All right, thank you. All right, let me turn then to, I believe, Mr. Abraham Merkin in the public gallery. Mr. Merkin, could you come forward to the microphone, please? Thank you. All right, you can take a seat. Mr. Merkin, could you just start off by stating for the record whether you're the account holder and to what percentage and that sort of thing?
So, Your Honor, yes, I am a creditor of the company. I've had an account with Hodlnaut since, I believe, 2021. That said, and just in light of, to some extent, what my perception of the way this has gone, and at the beginning of this process, I personally considered getting involved just on a bigger scale than currently am. The experience of the IJM's handling of the assets, additionally not addressing the burn rate as they handle the case, kind of makes me want to know what alternatives exist for the company and what alternatives might exist for either a restructuring plan or at least an alternative managed wind down. Whereas entrusting EY to do this after having lost assets with FTX, and I mean, we started at 0.31, we're definitely below that. So I haven't heard any disclosure on that. Not that that's been requested, but I would, as one creditor in a large group, be interested in hearing, more about the alternatives than just what the three creditors want.
All right. So, Mr. Merkin, I appreciate your need for information. So I'll ask for the affidavits to be, and future affidavits to be served on you as well, so that you have the same information as everyone else. All right. The broader issue, though, is that since this is a judicial management, it's not quite the same thing as a scheme of arrangement proposal. Although a judicial management can lead to a scheme, there isn't that level of consultation and engagement with the individual creditors as they would, as you would have when we get to the scheme stage. Because when it comes to the scheme, we'll of course have a meeting and voting and that sort of thing. But at this point, the judicial managers are under our framework, basically given a fair bit of discretion for them to exercise their judgments and to make their recommendations. So there's a bit of a difference there. But as I've said, I will ask for the information, the affidavits to be served on you as well, so that you are apprised of at least the thinking of the IGMs and any contrary views that might be expressed by the company, for example, all the directors. All right, Mr. Merkin?
Thank you.
All right, could I just, for the record, take note, what's your percentage holding as of whatever date you have? Just a rough estimation?
So I don't know the percentage at the time.
All right, what's the absolute amount as far as you recall?
The account balance, Your Honor, was approximately 280,000.
280,000 US, I assume. Right, all right. All right, thank you, Mr. Merkin. Anything else you'd like to say?
That's all.
All right, thank you, Mr. Merkin. You may go back to the public gallery. Thank you. All right, so that's Mr. Merkin's position stated. As I indicated, I have some concerns about the state of what is on the record and what I can exercise my discretion on. But I've also should hear out Mr. Randall Pereira on his client's application for removal of the IGM. Before that, can we just take a short 5-minute recess and we'll resume at about 11:15 or thereabouts. All right, short break at this point. All right, Annie, court stands.
Court is adjourned. We will resume the hearing now.
All right, we are resuming, and let me then have Mr. Randall Pereira in terms of both his position on the removal of the IGMs and any submissions he wishes to make in relation to the appointment of the GMs. All right, Mr. Pereira, thank you.
Yes, Your Honor. Your Honor, perhaps if I may, perhaps I will take the OA 451 submissions first before going on to the 360 set of submissions.
Yes.
So that it's all together, you know, here, all views. I think I would have perhaps broadly to summarize 3 points to make. The first is that I think this preliminary restructuring plan, I think, was put together sometime in the discussion started in mid or late November, and it was, I think, perhaps I would characterize it as only one round of feedback, and this round of feedback has been put to the creditors, and this is the response that we have received. So it's cursory feedback from 3 creditors. I do not in the letters see the creditors as rejecting outright all possible restructurings. What I hear from my learned friends is that the directors being in charge is an issue. There is there's an information gap which they therefore aren't able to make a decision. And I think I will address those points in a little bit more detail shortly. I would also say, Your Honor, that if I could take, Your Honor, perhaps if I could, Your Honor, just share my screen. Can Your Honor see? This is from the applicant's. This is from the judicial manager's bundle of documents, the volume 3, the one that they just recently filed. And this is the second IGM report. I think I just want to this list right here is what has been done by the IGMs. I would say in this regard, my submission is that there's quite a fair bit of work to be done to understand the affairs of the company. It does not seem like the full financial picture is available. And what the IGMs have done is mostly to secure assets. And I think through perhaps overtaken by events as well. Sometime in November, we had the FTX issue. So perhaps they haven't had the time, or whichever insolvency practitioner who we put in that shoes would not have had the time to deal comprehensively with a possible restructuring plan and outlook.
All right, sorry, Mr. Pereira, if I could stop you there. I think what I have to really lay out is that because this is not directly a scheme application, it's for judicial management, there has to be something put to the court to convince the court, not the creditors, the court, that the purposes can be achieved. And certainly it may be that the creditors support or the creditor's views will be relevant, but they're not determinative. And really the parties should be focused on convincing the court that the company can be allowed to have a go at, or rather the JM should be allowed to have a go at trying to keep the company going. So it's a very different situation from a scheme.
Yes,
Maybe
Your
that
Honor.
a scheme will be employed at some stage, but we're not there yet. So the threshold is to convince the court that I should that the JMs will have, our judicial management will have some hope of keeping the company going. So really then, it's not so much what the parties assess on themselves, it's what you can convince me of, really, Mr.
Yes, Your
Pereira.
Honor. Your Honor, my apologies. Put another way, what I'm trying to say is that what I hear from and I see from the letters, from the credit feedback given by the creditors on the restructuring plan is that there are two obstacles. One is having the directors at the helm, and second one is having insufficient information. If I could just also share my screen again, I would just refer directly to the letter from One Partnership 2, Your Honor. This is at page 5. This is the letter from Centric Custodian.
Yeah.
I think their key points is that they say that there is no follow-up on the IGN report as to whether a license is required, how Hodlnaut SG would be able to obtain the relevant regulatory approvals to continue trading in the event that's rehabilitated, and no details are provided in relation to the platforms which the alternative restructuring plan says that will provide a lockup for the assets to be traded. Coming down to let me just go down to page 8, where they say, I think there's some questions, I think the key issues that they've asked that I think also haven't been answered. And they say that there's no significant progress on these issues. I think this is, I mean, the whole point of the whole picture of it is that there's not enough detailed financial information available to, well, at least this particular creditor, who say that they are in favor of a restructuring plan. And put another way on, then my submission is that this is not insurmountable or this is not an obstacle, insurmountable obstacle, so to speak. It is a possibility, and there is a possibility that after the right financial information is provided, projections are provided, they would be able in a position to say that, hey, this restructuring plan would give me a better realization than if.
So it's for me to be convinced that that objective can be achieved.
Yes, Your Honor, and I get, okay. Further to that submission, Your Honor, my contention here is that there isn't, or at least based on the work done, the financial position and the sort of the affairs of the company are not clear at this juncture.
No, this is the day of the application, so
yes,
I will have to decide on what is before me today, and if there isn't enough, then one outcome would be that I say that the parties seeking a judicial management haven't put in what is necessary. The burden is on those seeking to have a judicial management order made to convince me that one of the statutory objectives can be achieved.
yes, Your Honor.
All right. So I appreciate where you're going with some of this, but the views of the creditors, the comfort of the creditors is not determinative. But
Yes,
that also, I think, brings us back to the question I had about what information is really available. I'm not actually convinced at this point that I have enough before me to make a JM order. But I don't generally want to pull the plug on companies too readily. I want to give them a chance, and those backing the company to have a chance. So that's why I raised the possibility of having an affidavit from Mr. Tan. And I am I can also give your client another go at
Yes, Your Honor.
putting in some evidence to convince me that one of the statutory objectives can be achieved. And I assume your client will be supporting the appointment of Mr. Tam, correct?
Your Honor, I would support that, but also in the alternative, I think the primary position is that the current IGMs are not suitable.
Oh, yes, certainly. But I mean, in terms of the positive case,
I think Mr. Tam was the director's preferred candidate, but
yes.
of course they would defer to Your Honor, Your Honor's discretion.
all right, but anyone else but the IGMs, basically, Mr. Tam or anyone else?
Yes, Your Honor.
All
Yes,
right,
Your Honor.
all right. So I will do that. I will make orders for that after at the end of the proceedings, so that you can have another go at trying to fortify your cases in respect of the viability of judicial management. But I'll have some remarks to make about that. All right, Mr. Pereira?
Yes, Your Honor.
All right. So then if we put that aside, should we proceed then to your arguments on the removal of the IJMs?
Yes, Your Honor. If Your Honor would be hearing the rest of my client's sort of position through the affidavits as well, I think that would be we can just go straight to 360.
All right. Let's proceed then with your arguments on the removal.
Yes, Your Honor. Well, perhaps I might just start by let me just start by making some, I think, some preliminary remarks in relation to 3660. I think there was some back and forth in the affidavits over whether 3660 was brought for a political purpose, and it was brought to secure a judicial manager who is quote unquote friendly to the directors. I would like to say that that is not the case, because any judicial manager that is appointed owes a primary duty to court. And if given what has been laid out in the first and second IGM reports, I think whatever has been flagged will, in any insolvency practitioner's view, have to be investigated. So that is I think that would make it really a separate point, quite a separate point. So Your Honor, the focus of the hearings should therefore be, I think, on the applicable test for whether a creditor removes, how a creditor removes the judicial manager, and the IGM's conduct of judicial management. I think that's what is an issue. Would Your Honor require me to take Your Honor through the law on this?
And not necessarily, but you can summarize it if you wish for the record.
Yes, Your Honor. I think, Your Honor, my submission would be that I think that the Court of Appeals decision in Yihua Lifestyle is not on point in this case, because it deals with, in the context of impugning a specific decision of a judicial manager. That's where the unfair prejudice test was used. I would say that the UK authorities in this case are persuasive, partly because I think the UK Insolvency Act and the IRDA, Informal Companies Act, are impaired material. And the UK has applied the test for removal of liquidators for cause in the case of administrators as well. So I think that's a consistent position, I think, between Section 108 of the UK Insolvency Act and the relevant provisions, I think 115 of the IRDA. And in this case, I would then say that a removal for cause is whatever is in the real, substantial, and honest interest of the administration or liquidation. And I think the authorities are quite clear that it does not have, there does not have to be a wrongdoing on the part of the judicial manager if his competence or integrity is impugned or placed in a position of inherent conflict that's prejudicial to creditors and contains a real risk of defeating the objectives of administration or liquidation. So that is my submission on the law, that the UK authorities, and also that the real substantial honest interest of liquidation, this for-cause test, has been applied in the context of removal of liquidators in Singapore. So that would be consistent all around.
Yes.
I think so. I mean, I think my learned friend has Ms. Tia has already summarized the law on what the purposes of a judicial management are, and I won't make those submissions again. I will only say that, as I mentioned, Your Honor, perhaps at the start of the hearing, that even if, Your Honor, if I don't hit the threshold for 3660, and to show that there is cause to remove the IGMs, Your Honor, these submissions also apply with equal force to Your Honor's discretion in appointing judicial managers over judicial managers or liquidators, as the case may be, in respect of the company. If I could take Your Honor perhaps to my written submissions, previous written submissions, I believe it was filed 14th November.
Yes.
At paragraphs 47 and 48, Your Honor.
All right.
I think it boils down to two factors in my submission: competence and integrity of the insolvency practitioners. And I say this with the greatest of respect, that it's not meant as a slight against Mr. Loh, Ms. E, who I think have taken charge of many companies in many other industries. I mean this narrowly in the context of this judicial management and the cryptocurrency space. If I could take Your Honor perhaps to paragraph 52.
Yes.
This is Justice Neuberger, as his lordship then was, and I would just say that the full cause for removing can be made out in varying circumstances, and not simply because the liquidator has acted wrongfully or ineptly. It simply means that circumstances have arisen that the court considers it, that there was cause to remove him. So the thrust of my submission is that the IGMs are not particularly suited to or do not particularly understand the nature of the cryptocurrency business and to navigate its nuances and pitfalls. And in this case, I think it's particularly relevant that they may have, and I use the word may have because I think there will be no determination. It's not before Your Honor. They may have caused a loss to the creditors of a tune of more than 18 million Singapore dollars. Then, and secondly, I think quite a few of the communications by the IGMs to the creditors in my submission appear to be wanting in quite a few respects. The thrust of it is that every time they give information to the creditors, sometimes it creates more questions than it answers. And this, in this regard, I would take Your Honor to specific issues. Perhaps let me start with the FTX issue.
Yes.
If I can take Your Honor to my bundle of documents, this was also filed, I think, for the previous hearing. At page, I think 1189. That's 1189.
All right, hold on a moment, please. Yes, carry on, please.
Sorry, 1191. Sorry.
1191. All right. Yes.
Just wanted to sort of close the loop on the figure. I think it's at the bottom of the page under centralized exchanges. Breakdown by centralized exchange. I think 71%, 71.76% of the assets of Hodlnaut SG held by were held with FTX, or are still held with FTX.
Sorry, where's that on the page again? Say
It's at
1191.
it's table 15, breakdown by centralized exchange, page 1191.
Yes.
It's the first
All right, the figure there
column.
for FTX. All right. Carry on.
And in this regard, I think if I could then bring Your Honor to page 1081.
Yes.
This is the 16th circular of the RGMs. I think it was on 11th of November. It's shortly after FTX did withdrawals on the 8th of November.
Mm-hmm. All right.
I think the point here is this disclosure just basically says that they were already, I think, and it's here in the first, second, third paragraph, it says that prior to the announcement, the IGMs were already closely monitoring the news, information, and updates relating to the issues between FTX and Binance, and also looked into the steps they could take to protect the company's position. I would, Your Honor, put a pin in this and come back to this statement again, just a little further down in submissions. If I can then take Your Honor to page 1084. So that's 3 pages down, Your Honor.
All right. Yes.
This is a recording of a conversation, I think, between the IGM staff and I think it's Zhu Juntao. And I think the two critical points, or where I point to, is first, Ramesh's statement at the top. We'll probably need, and I read, so for those exchanges, we will probably need to know the account information, so we can let the exchanges know to freeze the accounts. And Mr. Zhu's statement at the end, which is that you shouldn't be freezing the account. I think you should retrieve those assets off the centralized exchange. And I believe this was sometime very early on in the judicial management. I think before there was any acrimony between the directors and the IGMs, before any acrimony had developed. This was one of the first few meetings between the parties. If I could then take Your Honor to page 1090.
Yes.
This is it's an email split into two, but I think the material portion is highlighted. This is an email from Mr. Zhu to Mr. Richard Gardner, copying the rest of the IGM team. And I read here, as mentioned during our previous meetings, the better option would be for EY to take over our accounts on the centralized exchanges as soon as possible and transfer these assets to a wallet in EY's custody. Our assets are earning interest on FTX, and freezing assets on such a platform increases the risk of asset dissipation. Simon and I would disagree that freezing assets on centralized exchange providers is the best course of action. This was on 5th September 2022, Your Honor. And then again, if I can take Your Honor then to page 1055.
Yes.
Under point 1, I think this is the notes, the IGM's notes of a meeting on 6th of September 2022. And this is where I think I'm just going to read the first section on custody of digital tokens, where, Your Honor, I think Mr. Zhu again advised that there will be risk attached to the custodian option, and that would be better to hold digital tokens in self-custodized wallets. The significance of this, Your Honor, is that the assets, if you have on a centralized exchange, there's always a counterparty risk and a risk that the assets are lost in the event of the insolvency of the exchange. And I think my submission or position is that an insolvency of a traditional finance exchange is, today, I think that would be considered a black swan event, but in the cryptocurrency space, it's not an unheard of affair. and it happens with, I guess, alarming irregularity.
Mm-hmm.
So coming back to the circular, Your Honor, I think the IGMs have said that they took steps to withdraw perhaps on the evening of the 8th of November or the 9th of November, and that was too late.
Mm-hmm.
Your Honor, and I think, Your Honor, in my submissions, I have also set out the sequence of events as to why I think I say, or why my client says that there were warning signs to FTX going under, and that these warning signs are heeded. And well, first of all, the assets should have already been removed. That's the first point. And the second point is that these assets should then have also that if they knew at that point in time, they should have removed it.
Mm-hmm.
If I could just take Your Honor perhaps to then take Your Honor, I think Your Honor gave directions for a second IGM report and an affidavit of Mr. Aaron Low to address these issues.
Mm-hmm.
And Your Honor, in this regard, I think my submission is that it really begs more questions than it answers. And I will take Your Honor through my points on this report. I think the first question, Your Honor, if I could take Your Honor now to the applicants bundle, page 45.
The applicants bundle.
That's correct. The volume 3, the one most recently filed.
Yes. Page 45 of volume
45 of volume 3.
Volume 3. Yes.
This would be the second IGM report, Your Honor.
Is this second report? Sorry, page 45. Which tab is this, Mr. Per?
Let me just tab 11.
Tab 11.
It is Mr. Aaron Low's affidavit.
Sorry. All right, let me just be clear. Which bundle? The applicants bundle, meaning the
Sorry,
company's bundle.
Your Honor, the judicial managers bundle. I'm
Judicial
so sorry.
managers bundle. All right, thank you. Hold on.
Sorry.
Tab 11. All right, thank you. Mr. Aaron Low's affidavit, page 45.
Yes, Your Honor. That would be paragraph 3.3.10.
All right, thank you.
I think they allege that their inability to withdraw Hodlnaut SG's balance was due to, and I just read, is unsuccessful due to a sudden apparent change in the company's account access rights that was not present before.
All right.
We have, Your Honor, and if I could just share my screen, written, and we did allude to this letter in our. Oh, we did mention that this was part of the correspondence that transpired in our letter to the court. We did ask, and we asked the IGMs to, if I could just ask Your Honor to look at paragraph 4.
Yes.
This is we asked them what's this apparent change, how this change was discovered, and why this change was not detected. Your Honor, I think to date we haven't had a reply on this. They have replied to our letter, but they said that they would reserve submissions before, Your Honor. So I think that's their position. And I think, Your Honor, coming back to my bundle of documents, if I could just take Your Honor to page 8. Let's see. If I could just take Your Honor, just give me a moment. Again, to 1084, back at the same place that I took you on to tab 8. And I read from Ramesh's exchange. This basically, he's saying that we can communicate, and I think we can communicate the exchange to freeze the accounts. For example, I think that was an intention that they had since the start. Since the start of the, and I think what the reason why my client asks these questions is because they suspect that this sudden apparent change was the IGM's own doing, which is that they froze the account and they could not unfreeze it. Of course, the client doesn't have evidence to suggest, but it has a number of material correspondence where the IGMs have said that they will freeze the accounts on centralized exchanges. And so I think this is clarificatory in nature because they want to know what is, I think it's material for the creditors to know what this sudden apparent change is that's stated in the second IGM report. And I think further to that, if I can just bring you on back to the second IGM report again. At page 46 now, same paragraph, but over the page. Where the IGMs allege, I think, and I read that they only withdraws small amounts generally below 50,000 were allowed, as opposed to large withdrawals generally above 1 million, like the IGMs were trying to do. I think significantly, and this is, I fully accept, Your Honor, that this is not before Your Honor on affidavit because I think the second IGM report came out after, and my client, but I understand from my client, and he has retrieved on-chain data that suggests that what is said here is not true. If I could perhaps take Your Honor back to this letter that we sent to my learned friends. And I would say at paragraph 6 that this is the submission, Your Honor. That there were significant withdrawals from the FTX hot wallet up to 11th November. And that there were also multiple withdrawals. Some certain individual entities had withdrawn significant sums by making multiple withdrawals under 50,000. And if I could just take Your Honor to the, and I would, if Your Honor directs, would have this put on affidavit as well. So this is the transaction list for USDC. I think it's a sample just pulled out by the client. I think the number one address withdrew, I think, on 8th of November, withdrew 134,833,521. USDC is roughly 1-to-1 equivalent to US dollars. So that's about 135 million US dollars. And the list goes down this way. The ones highlighted in yellow, Your Honor, indicate that they are withdrawals. Let's say this is 2.9 million. And if Your Honor could, I think it's rather small, but the date is here, Your Honor. And this is for USDC. USDT has also a similar set of sample transactions sent to single wallet addresses. The ones highlighted in yellow also happened after the 8th of November. And the one highlighted in red, Your Honor, this is, I think it's significant because somebody or some entity withdrew 5.5 million in 141 transactions, each below 50,000. But the average mean transaction amount was 38,900. And I think this, I'm not saying that this is that there's conclusive evidence of fault on the part of the IGM. I just say that it calls for an explanation and also that this should be investigated. The next point, Your Honor, is that if I can take Your Honor to page 68.
Page of which bundle?
68 of the Judicial Managers bundle.
All right.
Same IGM report at 7.3, paragraph 731.
Mm-hmm.
I think, and I read, as a starting point, the IGM's primary mandate is to preserve and protect the company's assets and not trading for profit.
Mm-hmm.
I think this is, I think, important in the grand scheme of things, because given their mandate or their stated mandate, it would be important for them to explain to the creditors or for somebody to investigate whether they considered whether they considered the counterparty risk of a centralized exchange and whether this was worth it in relation to discharging their mandate.
Mm-hmm.
And in my submission, I think they are not conscious of this risk at all. I would say, if I could take your back to page 45 of the same bundle,
Mm-hmm.
at paragraph 3.3.9.
Mm-hmm.
Here, like in the second IGM report, they say that as soon as there were credible news reports and information that the sudden bank run had led to sluggish withdrawals from FTX, the IGMs proceeded to reach out to Binance on 8th of November to seek confirmation. I guess the first question is why, or rather the striking question is that Binance is also a centralized exchange.
Mm-hmm.
Why as a first port of call would the IGMs reach out from one centralized exchange, knowing counterparty risk, being warned generally of counterparty risk to a centralized exchange? Why would they reach out to another centralized exchange to keep the assets?
Mm-hmm. Mm-hmm.
And also, then the question also arises as to why would they have to wait for Binance to respond before they transfer the assets out if they knew that there was a bank run going on?
Mm-hmm.
And also, I think, Your Honor, if I can perhaps take Your Honor to, let me just, my apologies, Your Honor, I just need to find the page.
Yes, so
Yes.
yes, Mr. Pereira, if I could ask you to zoom in on your main points.
Yes, Your Honor. Okay. So if I could take Your Honor to page 43 of
Mhm.
the bundle,
Yes.
the same bundle.
Mhm.
My point is that eventually the IGMs eventually put the assets in cold wallets under their control. In
Mhm.
any event, at least whatever is left from the other exchanges such as derived. My point is that these are all things that require investigation, and it may or may not be that the IGMs were negligent in their discharge of their duties vis-a-vis FTX. But I think the submission has two limbs. The first is that there is potentially a contingent liability against the IGMs personally, and this puts them in an inherent position of conflict vis-a-vis the conduct of the judicial management or insolvency, as the case may be, because there is potentially a claim against them for $80 million.
Do you have any authority for the proposition that IGM appointed by the court would be liable in this way?
No, Your Honor, but I would say that the order itself, when it says that the GMs are not liable, it relates only to
yeah, but the
contracts.
GMs are officers of the court, so you would be very surprised they have direct liability in that way.
Yes, Your Honor, but further to that point also, that the second point is that then it brings to mind that no reasonable minded creditor, knowing the full facts, would have confidence in the IGMs that they.
So that begs the question again. Again, this is not a debtor in possession or creditor scheme kind of situation. It's the court.
Yes, Your Honor.
Yeah.
Yes, Your Honor. And so the core of my submission is that this puts them in a position of conflict. They have, or at least there is reason to believe that they may have lost $80 million of creditors' money. And I think all of the conduct of their actions will be viewed through that lens. And so I think it's not so much maybe there is or is not a conflict, but there's also the appearance of a conflict of interest.
All right. So again, Mr. Pereira, I think I'm not sure that we are looking at it from the same perspective. As I emphasize again and again, the IJMs and JMs are officers of the court. The governance of their conduct and their liabilities will be taken separately or differently from a situation where from a scheme type situation or a debtor in possession kind of situation. You see? So I'm not sure how far you can go with this kind of apparent conflict and all that. It's really for the courts. If the parties had wanted to go for a scheme or something like that, then yes, the remit would be quite different. But once you trigger a JM or IJM, it's a very different situation. The courts are there, and the IJM and JMs are officers of the court. The duties are not owed directly to the creditors. Yeah.
Yes, Your Honor.
So I think that will be the primary basis in which we will have to tease out the obligations or the rights of the IJMs and JMs.
Yes, Your Honor.
All right. Anything else?
Your Honor, I think then my submission then would be that all this goes towards the competence of the judicial managers in Your Honor's assessment. They were warned about this. They were not conscious of the risk. They went about not conscious of the centralized exchange risk, and it's symptomatic of a wider lack of understanding of the cryptocurrency space, Your Honor. And that is the core of my submission for their removal. I started off by saying that there were two headers. One is integrity, and the other is competence.
All right.
And yes, Your Honor.
All right. All right. Thank you, Mr. Pereira. Anything else you'd like to highlight in terms of competence?
Your Honor, I would say, and I could perhaps then, in terms of competence, could I just, I would want to share this screen, perhaps, Your Honor.
Yes.
This is a filing for FTX Chapter 11. This is the declaration, I think the initial declaration made by the restructuring professional put in charge of FTX. And I would just mention that this is the first thing that he did. This is, I think that is in stark contrast to what the IJMs. No, Your Honor. I think
taking it
the
from
filing came out after. Yeah.
All right. So no, but this is not anywhere in your bundles, correct? This is just what you're extracting freshly now?
Yes, Your Honor, from I think from US court records.
All right then. All right. So your basic point is that they put it into cold wallets right at the get-go.
Right from the get-go, Your Honor.
All right.
Yes, that is my point.
All right, thank you. All right, anything else, Mr. Pereira?
Your Honor, I have mentioned quite a number of other submissions, other points in my submissions, I think, in relation to the presentation of ETH puts, why that is not appropriate and why that has disguised certain losses to the company from the creditors. Unless Your Honor, and I hear Your Honor that Your Honor's would like me to wrap up my submissions, unless you're
not wrap up, but just zoom in on your main points. You can go into it. I'm fine with that.
I think I will not state what's already in the submissions, and I will just only zoom in on what has been perhaps explained in the second IGM report. If I could just take Your Honor to page 68 in relation to the ETH options.
Yes.
I think they say that the presentation is fair. This is paragraph 7.3.5. Because changes in the fair, and I'm reading from the last line of the paragraph.
Yes.
That the changes in fair value to these ETH options are recognized directly in profit and loss. Your Honor will recall that
Yes.
Your Honor will recall that the options were paid. They weren't paid in cash; they were paid in ETH, and whatever the cash out was also in ETH. So our core submission is that if you present it in fiat and you recognize a currency gain, why is that not disclosed? And the answer to that, the IGM's answer is that these will be recognized directly in profit and loss. I think a simple point here is that this should have been presented to creditors. They should have known what was the true value of the loss to the company from this trade. And just perhaps go down the line and onto page 69, Your Honor. We had raised the issue of some additional trades that were entered into by the IGMs. And this, I think their explanation is simply at paragraph 7.3.12 to set out the chronology of events as to of when the trades were entered into. I think that there's no explanation here, and it's really calls for further questions. But really my point, Your Honor, is that there's scant disclosure, and every time something is disclosed, you have to ask additional questions. And when you ask additional questions, the explanation does not, it gives the impression that the IGMs have something to hide. And because when you ask a question, why was these trades entered into, they tell you these trades were entered into on these dates. They don't tell you, given their mandate of only preserving assets, what was the rationale, what's the underlying rationale. So that, I think that goes to my submission, really. Competence, disclosure, whether there is sort of an honest disclosure with the creditors, and whether the IGMs are the best people to disclose all these things. Maybe to their credit, they don't understand the industry, and therefore this is the best disclosure they can give, Your Honor. So I think that's as far as I'll put the submissions.
All right, thank you. Mr. Leo?
May it please the court. Your Honor, I will try to be as brief as I can, and I hope to complete my submissions, Your Honor, hopefully within half an hour, if there are not too many questions, Your Honor.
What I propose to do for this is to spill into lunch if necessary, so that's all right.
I'm grateful, Your Honor. I'll try to be as brief as I can, because I think, in fairness, the points can be dealt with quite simply. Your Honor, I start with the law, because I respectfully disagree with my learned friend's analysis of the appropriate test, Your Honor. Your Honor, my submission is the appropriate test is the test that was set out in the Court of Appeal decision in Yihua versus HTL. And Your Honor, perhaps the best way I can do this is to refer to my written submissions, where I both set out the two provisions that Mr. Lee relies on to seek a removal of the IGMs, in particular section 104A of the IRDA, the IRDA, and also 1151A of the IRDA. And then there is a quote from the decision of Yihua. Your Honor, so if I could refer Your Honor to my written submissions, in particular, Your Honor, page 18 to 21, paragraphs starting 44 to 49.
Yes.
And Your Honor, my first point is that Mr. Simon Lee's application has to be considered on the basis that he has brought it. That means, Your Honor, first and foremost, Mr. Lee doesn't say his application is premised solely on section 104A of the IRDA, or 1A. He premises it both on section 104.1A of the IRDA and, Your Honor, section 115.1A of the IRDA. And Your Honor, if Your Honor looks at the thrust of Mr. Simon Lee's first affidavit. And in particular, Your Honor, I don't need to ask Your Honor to turn it up, but I would just reference for Your Honor's record paragraphs 7 and paragraphs 10 of Mr. Lee's affidavit, Your Honor.
Right.
And in these paragraphs, Your Honor, I think it will be readily apparent that the entire basis on which he brings the application to remove the IGMs is on, in his words, the unfairly prejudicial management of the affairs of the company by the IGMs. Your Honor, that is the language of section 1151A of the order. And Your Honor, turning back to my submissions, I did have an initial point on the language of 104 versus 115. Your Honor, at paragraph 44, we cite both provisions. Your Honor will note that for 104, it only refers to the judicial manager of a company may be removed from office by order of court. It doesn't reference interim judicial manager. In contrast, Your Honor, 1151 specifically says that at any time when a company is in judicial management or interim judicial management, a creditor or member of the company may apply to the court for an order under this section on the ground of, and the 1A says that the company's affairs, business and property are being or have been managed by the judicial manager or interim judicial manager in a manner that is or was unfairly prejudicial to the interests of the creditors or members generally. So, Your Honor, my point here is that the order, in fact, envisages that generally where a creditor is unhappy with the unfair or prejudicial management of a company by an IGM, one would think that 1151A is the proper provision on which he should proceed. And Your Honor, when Your Honor looks at the primary issue that my learned friend is now complaining of, in particular the issue of FTX, Your Honor, the complaint is not generally in relation to the IGMs being unsuitable, though I know my learned friend makes that point as well. But the main complaint, at least from the affidavits, and I'll make good that point, Your Honor, is that there has been unfair prejudice because the IGMs essentially took the wrong decision. My learned friend's submission is that they should have transferred all the digital assets that were held on FTX into a digital hardware wallet. Your Honor, I'm going to go into Ihua, but I just wanted to correct a point right at the outset, Your Honor. This is not a case, and Your Honor will see it from the documents in the record, where the IGMs were simply not aware of the issue of counterparty risk, and they had ignored the issue totally, Your Honor. The record is clear. Before the first warning sign that Mr. Simon Lee says, the IGMs were already considering the three options on how do you hold these digital assets. Do you keep it on a centralized exchange? Do you put it with a third-party custodian? Or do you go with a hardware wallet? Your Honor, those were the three options. The record is clear that the IGMs were actively considering the issue. It's in fact discussed in the first IGM report. And Your Honor, what is also clear in the first IGM report, which was filed on the 27th of October initially, later refiled on the 1st of November, is that of the three options, the IGMs have already made clear to the creditors and to Your Honor that in their view, the most optimal way of protecting the assets is by use of a third-party custodian. So, Your Honor, my learned friend is not correct in submitting that, oh, they were not considering counterparty risk at all. Your Honor, I think that's wrong. They were considering it, but they made a particular decision, and they were already in discussions with third-party custodians, Your Honor, as early as 7 September, months before the FTX collapse. There were some issues on the opening of the account that remain today, but the IGMs continue to be of the view, Your Honor, that this is the optimal route and they are continuing to pursue it. So when Your Honor looks at the issue, it is really not an issue of IGMs have done something wrong. The issue is their decision to go with third-party custodian something that is unjustifiable? And that's why I say, Your Honor, that the test in Yihua is applicable, because in that case, Your Honor, what the court was saying is that an IGM or judicial manager needs to be given wide discretion to do their job. And the court will not interfere with their decision, or for that matter, Your Honor, take the draconian remedy to remove them unless a stringent test is fulfilled. Your Honor will be familiar with the test because, Your Honor, the High Court decision, I believe, was decided by Your Honor. And I think the Court of Appeal approved Your Honor's ruling in that case, that first you need to show there has been some harm to the creditor who is making the application. Your Honor, we are prepared to accept that for the purposes of this case, that limb is fulfilled. The second limb of the test, Your Honor, is that the decision of the IJM or JM has to not have any legal or commercial justification. And that's not enough. Even if there is no legal or commercial justification, the Court of Appeal clarifies that the court will only interfere if the decision is perverse. And Your Honor, I just wanted to show Your Honor the paragraph to make good my submission. Your Honor, that's at paragraph 47 of my written submissions. We cite Yihua, and I quote in particular paragraph 17 of the Court of Appeal's decision. 17A reads the first limb. First, it must be shown that the action complained of has caused or would cause the complainant to suffer harm in his capacity as a member of creditor. We're prepared to accept that may well be fulfilled. B, second, the harm caused by the action complained of must be unfair. In this regard, unfairness may stem from the following. And the first, Your Honor, the Court of Appeal mentions conspicuously unfair or differential treatment to the disadvantage of the applicant. Your Honor, I don't think that limb is applicable because this is not a case of one particular creditor or class of creditors being treated differently. And the second limb is a lack of legal or commercial justification for a decision which causes harm to the members or creditors as a whole. And Your Honor, at the last line, however, in such cases, the court will not interfere with the JM's decision unless it is perverse, i.e. unable to withstand logical analysis. So, Your Honor, the question that Your Honor is truly faced with is that given that on the record, it is clear that the IGMs thought that we'll go down the route of the third-party custodian. Is that a decision that is devoid of legal or commercial justification and perverse? I accept, Your Honor, there is a secondary consideration as to whether the IGMs ignored warning signs. But, Your Honor, this brings me to my second important point. And I, again, can do no better than referring to my submissions and affidavits, Your Honor. And if I could refer Your Honor to the fourth affidavit of Mr. Aaron Low, one of the IJMs, Your Honor. Sorry, Your Honor, if you could give me just a second to pull it up. And Your Honor, I was going to refer Your Honor to paragraph 33, and in particular, Your Honor, paragraph 33E. But maybe before I do that, I just show Your Honor paragraph 33C as well. That's at page 15, Your Honor.
All right.
So, Your Honor, thank you, Your Honor. Your Honor, paragraph 33C, I just wanted to show Your Honor that it's on affidavit that the IGMs, Mr. Low has already stated, sworn evidence that upon the IGM's appointment, their priority was to secure Hodlnaut's assets, which include securing controls over Hodlnaut's digital assets. The IGM's view is that employing the services of a reputable third-party cryptocurrency custodian is the most optimal approach with respect to the custody and control of the digital assets. Paragraph 33D, concurrently, while the IGMs were in discussion with various third-party custodians CoinDesk Inc. issued a report on 2nd November 2022. Your Honor, that report was the first of the warning signs that my learned friend has mentioned in his written submission. Your Honor, I would submit that if Your Honor looks at the article, it's nothing to do with FTX. And I'm not sure it even shows that FTX has a liquidity issue, because what it's talking about is Alameda Research, a separate entity. And the question there was really that a lot of Alameda Research's assets were pegged to FTT, a token that is native to FTX that are issued by FTX. But it wasn't any suggestion at that point in time that FTX is somehow going down. But Your Honor, I think what's really important is the next paragraph at 33E. Your Honor, 33E we first talk about on the 6th or 7th November, and Your Honor, it's really in Singapore time, 7th of November, where we talk about a bank run. We use colloquial terms, a bank run on FTX. But that was triggered by Mr. Chang Ping Zhao, I think he's generally known as CZ in the industry, the CEO of Binance, tweeting that he was going to liquidate Binance's FTT, holdings in FTT. But Your Honor, the use of the word bank run, I think, doesn't give enough import to the terms and conditions of FTX. And these terms and conditions, Your Honor, are extremely important because those terms and conditions would have been front and center in the mind of the IJMs, but also any other party who places assets with FTX. And Your Honor, these terms and conditions make clear that the digital assets placed with FTX are owned by the customer. And that, in fact, Your Honor, let me read the provisions because they're important. The first is, title to the customer's digital assets shall at all times remain with the customer and shall not transfer to FTX trading. As the owner of the digital assets in his or her account, the customer shall bear all risks of loss of such digital assets. Your Honor, B, I'm sorry, I'm skipping over some of it, Your Honor, just to get to my main points. I apologize. If anything, Your Honor wanted me to go into more detail, I will. B says, Your Honor, none of the digital assets in the customer's account are the property of or shall or may be loaned to FTX trading. And C, Your Honor, the customer controls the digital assets held in his or her account at any time, subject to outages, downtime, and applicable policies. The customer may withdraw his or her digital assets by sending them to a different blockchain address. Your Honor, the long and short of it, this is similar not just to an IJM or JM placing fiat currency in a bank, in a normal bank account. It's actually, Your Honor, more akin to placing it in a trust account in a bank. So, Your Honor, even if we take Mr. Lee's case at the highest, that there were some warning signs about the liquidity of FTX, as long as FTX weren't fraudsters who were not complying with their own T's and C's and essentially stealing customers' monies, these customers' monies would not be lost.
Mr. So I'm not sure I would think it's entirely sound to make the argument that FTX or any of the other crypto exchanges should be treated in a similar way to banks and that sort of thing. I think the only concern I have is that this industry is still nascent and that some caution would have been appropriate. But I think ultimately my concern is whichever test, and I'm not sure I need to actually choose between your formulation, Yuhua, or Mr. Pereira's formulation on the basis of the UK liquidation section. I may not need to choose between them, but whatever test is applied, I think I would not be minded to really look at things with 2020 hindsight, and that I appreciate some leeway will have to be given to parties to deal with the with evolving situations. But where I'm skeptical about is really the argument that we need to, or rather we can equate FTX to a bank or anything, or any of the crypto exchanges actually. Right?
Yes, Your Honor. Your Honor, I accept the point. I'm not, I think, making the submission that FTX should be treated like a traditional financial institution. Your Honor is absolutely right that the regulations are perhaps not as stringent, if I'm being kind. Your Honor, and obviously that may be one of the attraction of cryptocurrency that is less regulated. But what I was trying to say, Your Honor, maybe it's a more nuanced point, and I'm sorry, Your Honor, perhaps it's my fault for not being clear. I was going to say, Your Honor, that when we look at warning signs, we do have to look at warning signs about what? And I think the IGMs were entitled to, and I think that it's not just the IGMs, Your Honor, because Your Honor would know that apart from the IGMs, there were many respectable and large financial institutions like Temasek Holdings, Sequoia, SoftBank, and also parties that were familiar with the cryptocurrency industry like Galaxy, Genesis, all with hundreds of millions of dollars either invested or placed with FTX. And Your Honor, I'm just making the point that, as Your Honor says, we shouldn't look with 2020 hindsight. We look at the IGMs who see that that FTX is firstly I think second largest cryptocurrency exchange by trading volume. So we're not talking about some run-of-the-mill small exchange that may have collapsed. Secondly, it has all these large investors who have done due diligence before investing into FTX. There are other cryptocurrency funds who hold millions of dollars with FTX and also are faced with the unenviable position of not having been able to withdraw their assets and potentially have suffered loss. And coupled with that, Your Honor, with the terms and conditions of FTX, which seem to make clear that these assets are supposed to be held essentially on trust for the customer. I accept that on hindsight, perhaps IGMs or anybody else shouldn't have trusted FTX, but hindsight is 2020, Your Honor. And I think that what Mr. Simon Lee is trying to do is to hold the IGMs to an impossible standard. And I say that because it's a standard that Mr. Lee himself doesn't appear to be able to meet. Because, Your Honor, notwithstanding some initial conversations about which is better, do we freeze on a centralized exchange, do we go with a third-party custodian, or do we put in hardware wallets, Your Honor will see that when all these warning signs have come that Mr. Simon Lee now says, oh, it's so obvious FTX has issues, not once from the 2nd or the 6th or the 7th of November did Mr. Lee or Mr. Zhu Jintao tell the IGMs, I saw that in your IGM report, you said that you are in the process of trying to move the funds to a third-party custodian. You have to move now, FTX is going down. Your Honor, there's only two, in my respectful submissions, reasonable interpretations of their silence. One is that they themselves didn't expect FTX to go down, and because of that, Hodlnaut would lose its assets, potentially lose its assets. The other is that the directors thought that FTX might be in trouble, but they thought, well, no, we won't tell the IGMs because we're trying to remove them. I think that may be a more uncharitable interpretation, and I think it's likely the former, that really the directors themselves didn't think that FTX was going down. And Your Honor, that's clear from the fact that we've cited some in our affidavit, Your Honor, but there are news reports of many other cryptocurrency companies which hold millions, some in the case of hundreds of millions with FTX that were not able to withdraw their assets. So ultimately, my submission, Your Honor, is that as of 8 September, I'm sorry, Your Honor, 8 November 2022, when the IGM sought to withdraw the balances that were held on FTX, were there warning signs that FTX was fraudulent, that they may in some ways not be complying with their terms and conditions? My submission is that none of the news reports suggest that. There were news reports that came later, after the 8th of September, and mostly after FTX filed for bankruptcy in the United States, where there were suggestions that FTX may have misappropriated customers' monies. So, Your Honor, that's really, I think, the core of my submissions on the FTX issue. But if Your Honor could give me a little bit of time just to check, and I think I should, for good order, show Your Honor the first IGM report where we had stated the considerations, Your Honor. And Your Honor, I think I can refer to the applicant's bundle of documents, and by applicant, I mean applicant in OA 451.
All right.
Bundle of documents, volume 2 of 3. And Your Honor, I would refer Your Honor to page 372. And in particular, starting with paragraph 4.2.27. Does Your Honor have it?
Yes, thank you.
Yes, Your Honor. So, Your Honor, again, in terms of timing, I think timing is really important, Your Honor. Your Honor, even on my learned friend's best case, the first warning sign is 2nd November 2022. And Your Honor, I've already explained to you that that warning sign related to Alameda Research and FTT, not FTX. But that's the first warning sign. Your Honor will see, and I just show Your Honor page 350 because that's the cover page of the report. It's the first IGM report. It's dated 1st November 2022, i.e. before the first warning sign. And Your Honor, actually it was filed earlier on 27 October, but there were some amendments, so it was refiled. So coming, Your Honor, to 4.2.27, and I will just read it because it's important. The IGMs have considered and assessed the following options with respect to the custody and control of the digital assets going forward. So, Your Honor, my learned friend is not correct that we're not considering it. Stated clearly here in the IGM report, continue to store the digital assets on the centralized exchanges. Second, transfer the digital assets to one or more self-custody cryptocurrency wallets to be held under the IGM's direct control, either in the form of cold, warm, and/or hot storage. So, Your Honor, it's not that they totally ignored the director's suggestion. It wasn't being considered. And third, employ the services of a reputable third-party custodian. So, Your Honor, they laid out the options, they considered it, and in 4.2.28, the IGM say, on balance, the IGMs considered that the more secure option would be to employ the services of a custodian. We are currently in the process of completing the onboarding formalities and account opening processes. We will provide a further update in our next report. So, Your Honor, on 1st of November, all the creditors, including Mr. Tu, Mr. Lee, they would have been well aware that the monies or digital assets held on FTX continued at that point in time to still be held on FTX. The IGMs have considered the options and they were taking the view that the right option is to go with a third-party custodian, but it had not yet been finalized and they were seeking to do so. Your Honor, after this report, we don't see any creditor writing to the IGM saying, I disagree with your course of action, this is wrong, this is prejudicial, FTX is going down. Nothing of the sort, Your Honor. It's only after FTX really went down that everyone with 2020 hindsight started to complain. And I don't think everyone has been complaining. It's mainly the directors. But, Your Honor, this is really the first IGM report. And I just wanted to, Your Honor, for good order, also show Your Honor the second IGM report where the IGMs have explained in a little bit more detail their considerations of why they thought that a third-party custodian is the appropriate and best course of action. And I'm sorry, Your Honor, let me find a reference for Your Honor. Your Honor, this can be found in the applicant's bundle of documents for OA 451, volume 3 of 3. So it's the Dix bundle. I'm so sorry for troubling Your Honor for picking up so many different bundles. Your Honor, page 461 of that bundle, it would be tab 22, if Your Honor has the hard copy. Does Your Honor have that?
Yes, thank you.
Thank you, Your Honor. Your Honor, I would refer Your Honor to 3.3.26. And that's the start of the custody of the digital assets with a third-party custodian. And it says here, as stated above in paragraph 3.3.6, the IGMs are of the view that the most optimal and secure approach in dealing with companies' digital assets is to deposit them with a reputable third-party custodian. The basis of this decision is discussed further below. And again here, Your Honor, 3.3.27, the IGMs have considered various factors with internal subject matter experts in deciding whether to transfer the company's digital assets through self-custody or cryptocurrency wallets, which are held under the IGM's direct control, or to employ the services of a custodian. So, Your Honor, the IGMs have stated clearly they were considering the option raised by the directors, but they have to exercise their independent judgment. And they set out the considerations. The considerations include inter alia, the security, the transaction risk, the capability of holding different kinds of digital assets, the availability to access to the company's digital assets and the cost. And 3.3.28 are some of the factors, Your Honor. After consideration, the IGMs are of the view that it's more secure to employ a third-party custodian than holding self-custodian cryptocurrency wallets, as the former has the following key benefits. 1, institutional grade custody, security architecture to manage cybersecurity risks. 2, quick and easy access to the company's digital assets if there is a need to convert, transfer or liquidate the company's digital assets. 3, availability of insurance. 4, well-developed operational and control procedures, protocol to mitigate transaction risks. And 5, availability of platforms for tracking performance of assets using customizable tools. So, Your Honor, I didn't want to delve into the details of, which is the best? Do you think digital custody wallets are better than third-party custodian? Because that's not the test. I think that, Your Honor, it's sufficient for me to say that there must be benefits to a third-party custodian that a digital hardware wallet would not have, because if not, all of these third-party custodians will go out of business. So, Your Honor, they must be offering a service. They must be offering something that is an advantage. So, Your Honor, regardless of whether or not Mr. Simon Lee disagrees that hardware wallets are better, it's not his judgment to make. And Your Honor, that's exactly, I think, one of the core issues in this case is that Mr. Simon Lee appears to take the position that the IGMs, you've got to listen to my instructions. I am the cryptocurrency expert. I'm telling you, you should put it in the digital hardware wallet. But Your Honor, the interim judicial management order is made precisely to have an independent third party come in to exercise independent judgment, not to simply rubber stamp and follow every decision that the directors are recommending. And Your Honor, I think it would be unfair and it would be wrong, Your Honor, to penalize the IGMs just because perhaps on hindsight, taking one option may have reduced the loss that was ultimately occasioned. And Your Honor, we don't know what the loss is, but I would just say, Your Honor, that I come back to the point that it's not the IGMs are alone. They are the only ones who have made this foolish decision to keep the money in FTX. There is hundreds of millions by different large institutions that remain stuck in FTX. I think it is incredibly unfair to try to hold the IGMs to an impossible standard that none of these other institutional investors or cryptocurrency funds were able to meet. And Your Honor, I didn't want to trouble Your Honor with dealing with all the other submissions that my learned friend have made, but maybe I just say a line or two on the Ethereum put options, if that's something Your Honor would be happy to hear.
You can summarize your position, thank you.
Yes, Your Honor, I will do that. On the Ethereum put options, I have just a couple of points, and I'll really zoom in on the key points, Your Honor. First, Your Honor, these Ethereum put options, the reason why the IGMs needed to do anything about them is because the directors entered into the puts in the first place. So this wasn't the IGMs trying to do a trade. What happened, Your Honor, is that the directors actually, after they applied for judicial management, then entered into these put options, which they now claim to say it's a speculative punt. Your Honor, that is what they did, not what the IGMs did. So even though they will put the company into judicial management, they applied for it, they decided, I shall now enter into these put options to sell these 500 Ethereum puts. Given the situation, the IGMs, when they were appointed, need to decide what to do with these Ethereum puts. Bearing in mind, Your Honor, the IGM's duty to preserve assets, that's their primary function, to preserve and protect assets. They're not in the business of trading for profit. I think it's not unfair for the IGMs to move cautiously and to consider the issue before making a snap judgment. Again, the directors will say, or rather Mr. Simon Lee will say, I told you to close the puts while they were profitable. But Your Honor, no one can time the market. I think that's a truism. They may say that it was profitable, so you should close. But Your Honor, they could be even more profitable. And given that the IGMs don't answer to the directors, if they felt in their judgment it could go even higher, then you wouldn't be closing it out. So ultimately, Your Honor, this is just a matter of market risk that the IGMs didn't create. It is the directors who entered into the transaction and the IGMs had to try to decide what to do about it. So Your Honor, again, I say that is extremely unfair to try to seek to remove the IGMs over their actions where they were genuinely trying to do the best for the company in the situation, and in this particular case, based on what the directors had done. Your Honor, I just to make sure that I've covered all the points in the written submissions of my learned friend, Your Honor, can I just say maybe 2 lines for each of the points?
All right.
And I thank Your Honor for Your Honor's patience, and I'm sorry that I've taken some time. Your Honor, if I can just turn Your Honor to my learned friend's written submissions dated 14 November 2022. I would start with page 18, Your Honor.
That's all right.
Paragraph 55. Your Honor, that's the first allegation parked under the heading of integrity and honesty.
Right.
I made the preliminary point that, Your Honor, I think at the last hearing, Your Honor had heard submissions from me that where you are alleging dishonesty, it is tried law, I think the case authority, among others, is Beijing Sino-Zonto, that you need cogent and compelling evidence to prove dishonesty. That's what they're alleging. None of the matters they cite in their submissions come even close to showing the IGMs are dishonest. On the bad blood allegation, I had addressed Your Honor in some detail during the striking out. I don't intend to repeat myself. I simply say that it's very clear from the affidavit that Mr. Low has been upfront from the start. He admits he told Mr. Gardner, one of the EY team, that his impression was that there may be black blood between Damodara and Ong. I shall refer to them as DO and the AGC. There may be, it's his impression. That's what he told Mr. Gardner. It's not dishonest, regardless of whether he was wrong about that. And I think in fairness, Mr. Low, having reviewed the correspondence, he's saying maybe he was wrong to have formed that impression. But that's not dishonesty, Your Honor. And what is crucial is that the first time Mr. Tzu emailed the IGMs and said, there was this allegation about a clear message of bad blood between DO and the AGC. The very next day, 6 September 2022, Mr. Low replies saying, there is no evidence of bad blood. On the 7th, if that was not clear enough, he says, I merely inferred that there may be bad blood. So, Your Honor, I think Mr. Lee can accuse Mr. Low of, or you had the wrong impression. But Mr. Low had clarified right at the outset that, no, I'm sorry, that was conveyed to you. That is not what was told to me. And so, Your Honor, I don't think he was dishonest. And actually, during the course of the emails, I don't want to trouble Your Honor with the emails, he made it clear that actually this doesn't impact our assessment. I don't know why we keep talking about this bad blood. So, Your Honor, it's really the directors making, I think, a mountain out of a molehill. Your Honor, the next one is at page 19, mischaracterization of the director's lack of assistance. Your Honor, I simply say that they may disagree, that they haven't been cooperative, or that the accounting records were not properly kept. We have set out in the first and second IGM report the basis on which the IGMs take the view that they have not been fully cooperative and why the accounting records are not properly kept. They can disagree with that, Your Honor, but we are not dishonest. We've clearly stated our basis, and Your Honor will know that for summons 4010, they have provided us information now. They've given us affidavits that they did not at the first instance without a formal application being brought. I don't want to make too much of it, Your Honor, but I just picked that point. Your Honor, number 3, page 20, FTX circular. I don't think I need to say more about FTX. Your Honor, page 21, number 4, misstatements in relation to the 30th September Ethereum puts. Your Honor, essentially, this point is simply about a difference in view as to the way to account for the profit and loss for the Ethereum put options. What is relevant, Your Honor, is the IGMs have stated on affidavit that they calculated it based on IFRS 9. So there is a basis for it. It's an international accounting standard because they consider these are derivatives. Your Honor, they can say, the directors can say, oh, that's not the most fair way of doing it. But that's not dishonesty. So, Your Honor, I think that can be dealt with summarily. This is certainly not a ground for removal. Your Honor, then we have, there's heading 5, page 22, failure to disclose additional options trade. The allegation appears to be that, oh, we are actually trading when we are supposed to be preserving assets. Your Honor, that's a misunderstanding on their part. We've made clear in Mr. Lowe's affidavit that what happened, Your Honor, was that they had to close out the 500 Ethereum puts, and 100 out of the 500 were not able to be closed out at a particular price. So what the IGMs did was to put in another order at a slightly higher price, which was filled. But then the previous order was also filled, Your Honor. So given that, the IGM needed to close out the previous order, and they closed it out at a profit for Hodlnaut. So, Your Honor, this is again an allegation that doesn't get off the ground. There's nothing untoward. Your Honor, then we have misstatements as to the withdrawal of funds by Mr. Tu Chin Tao, page 23. Your Honor, they talk about us allegedly misrepresenting whether Mr. Tu is a creditor or not, because he has, I think, less than 1/1,000,000 of a cent in his balance with Hodlnaut. Your Honor, the reason why we had stated that is because in the statement of affairs that the directors, including Mr. Tu, had prepared, where they stated Mr. Tu's total sum that is due, they put 0. So, Your Honor, the IGMs had thought that Mr. Tu was saying, since I only have 1/1,000,000 of a cent left, I'm okay. I mean, this is not, don't need to count me as a creditor. But given that now he says he's a creditor, we accept he's a creditor. The IGMs are not trying to deny him anything. It was based on the statement of affairs that he submitted. And Your Honor, I think in fairness, I need to say that there was a typographical error. And that's why for 86B, they say the correct sum withdrawn by Mr. Tu is 69 BTC and 707 ETH. There was a typographical error where it was swapped. So it was stated at 707 BTC and 84 Ethereum. The difference between 84 and 69, Your Honor, I think it actually furthers my point that the company's records are not adequately kept. There are different documents which show slightly different things. So all I can say is that 84 BTC, that's the correct one. The IGMs had based it on documentation that was in the IGM's possession given by the company. But there was a typo. Your Honor, a typographical error is not dishonesty. That's my submission. Your Honor, competence is the next. We have FTX at page 25. I'm not going to repeat my submissions. And I think at page 26, there's ability to understand financial records. I think, again, it's a difference in opinion. I think the IGM's position is that they are not keeping proper accounting records. And then the directors are saying, oh, because it's a cryptocurrency, we do it the way we want and you don't understand it. I'm not sure that is a fair submission by Mr. Lee to say we don't understand it. We don't understand what they were doing. I think that is probably the more accurate way of describing it. And so, Your Honour, with that, I wrap up my submissions. I was just going to say one point on, if Your Honour, I'm not sure whether Your Honour is going to make any order on judicial management today, but some of my learned friends' submissions now appear to be really geared more towards not so much removing the IGMs, but saying, hey, they are not the right choice for judicial manager. Your Honour, I think those submissions may be more relevant if there was going to be a rehabilitation of the company. But if in the event that it is really just judicial management to put the company into liquidation, then I think most of those submissions fall away. My learned friend may well say that the choice of liquidator maybe ought not to be my clients. They can make that submissions at that point in time, but it may well be premature for those submissions to be made. But I just say, Your Honour, that in terms of the claim with respect, I think the claim that the IGMs have caused some loss because of FTX is really a claim with no foundation. But in any event, even if my clients are appointed as liquidators, Your Honour will be aware of Section 240 of the IRDA, that if a creditor considers that the JM is guilty of some misfeasance or breach of trust, even if my clients are the liquidators, they can still apply to court to try to hold them liable. So it's not a matter of, oh, we can't have EY judging EY. If they feel they have a case, they can still bring a case under Section 240. But my respectful submission is that that case would be wholly without merit. And I think I've tested Your Honour's patience with my submissions, the length of the submissions, hopefully not the substance. And I thank Your Honour for your patience.
Right, thank you, Mr. Loh. Back to you, Mr. Pereira. Reply.
Yes, Your Honour. Your Honour, perhaps if I could start, Your Honour did ask me a question whether there's any authority on whether the judicial managers could be sued or could be liable to the company. If I could just share my screen, I think I'm just going to look further. I haven't found anything in Singapore on point, but I would just raise the IRDA, Your Honour. Just looking at, if Your Honour can see my screen, just looking at section 1125 of the IRDA. And this is the, it does not
yes, all right. I appreciate that, Mr. Pereira, but what I was concerned with was whether there'll be direct tortious liability. But whether or not you can invoke 1125, you can address it subsequently. All right, thank you.
Yes, Your Honour. I come also to the, I think, I do take Your Honour's point that Your Honour may not have to decide on which is the applicable test, applicable threshold, Your Honour. And I think I will only say here that if that in relation to the test in Yihua, my submission is that that's only applicable if it's...
Sorry, could you repeat that line, please?
I would only say that the test in Yihua is only applicable if I was seek to impugn a specific act of the judicial manager. I believe my learned friend did mention a couple of things about the warning signs relating to FTX. First of all, that the article on 2nd of November had nothing to do with FTX, and it was everything to do with Alameda and how they held tokens that were issued by FTX, basically TT, and most of the collateral that Alameda had was in fact these tokens that were sort of manufactured out of thin air by FTX. I think the first point is that this is if if the IGMs thought that this had no relation with FTX, then it sort of shows that they did not understand the industry. But I think the more important point is that when my learned friend pointed to the terms of service and said that everything, because the terms of service says that it's under customers' control, and therefore that gives some comfort to the IJMs, I think that is a sort of a red flag, because and he likened it to a trust account, which I think even in traditional finance, Your Honor, if assets are being loaned out on a margin or securities lending basis, there is no legal basis to say that the assets are yours, because it's not held for you on a custodian basis. Basically, the broker is basically trading or lending out your assets to other people. So I think that is a non-starter, Your Honor. Coming to the next point, that Temasek, Sequoia, SoftBank, and a number of other crypto firms, I think this argument is divided into two, right? One is investors.
I wouldn't put that much weight on it. I think choosing to invest is a different thing from being a customer or putting your funds into an exchange. You can move on to your next point, Mr.
Yes, Your Honor. And in relation to the crypto firms that have lost money, Your Honor, I would say that these firms were continuing on they were a going concern. They had continuing business. And that mandate is quite different from the IGM's mandate, which is to secure and hold the assets. So if they had to, because in the course of business, had to continue putting assets in FTX, I think that's a very different consideration.
Right.
And I think coming to the custody point, and I will be brief here, Your Honor, I think my learned friend did submit at length that they considered three options, actively considered the issue, talked about and decided that the custodian option was the best option, and therefore that was the course of action that they wanted to take. Your Honor, I think that, and in my humble submission here is that my learned friend's submissions are completely irrelevant, because the approach is not incompatible. You don't have, it's not a question of holding in a hardware wallet versus did you choose a custodian. The question here, and the fundamental question here, is putting it in a hardware wallet versus keeping it on the exchange. Because, and if I could just take Your Honor to their bundle at page 75. This is volume 3, page 75, the second IGM report. This is paragraph 825. And I read, as mentioned in paragraph 3.3.1 above, the IGMs have transferred the remaining positions held on the other centralized exchanges to a cold wallet as an interim measure until the custodian account has been opened. Your Honor, this is what they eventually did. And even if my learned friend's submission is right, that they've considered all the options, the custodian is beneficial to the company and to the creditors for a host of reasons. That's quite frankly irrelevant. The question is, why did you not take it out of the exchange pending the opening of the custodian account, which is what they eventually did. So, so the question then is really whether they applied their minds to having a hardware wallet versus sort of quote unquote freezing it on the exchange. And from what I hear from my learned friends' submissions, they were always considering that it was a binary solution, that it should have been one or the other, and they did not apply their mind to this at all. But I think the point here is not so much that there is a specific breach, or that the point is that there is possibly a breach of duty. The events that have transpired show that the IGMs may not suitably understand or do not understand the nuances of this industry, and I mean what my client considers basic mistakes in relation to this. And if I could just perhaps take Your Honor, to, and this comes back to my original submissions, I think, on the competence and the, perhaps I won't trouble Your Honor to look at the bundle. I would just make those submissions in 2 sentences. There's a backdrop of competence upon which I think Mr. Lee made his application. The first is that the blockchain person with the items didn't understand what Lido was. They didn't understand the basic terminology and functions of Google Drive. They had difficulty taking over the Fireblocks accounts, and they constantly misspelled what, I mean, it's Ethereum, right? There was constant so typographical, and I say typographical errors in the sense that they perhaps did not, were not familiar enough with the material that they made these errors. The point being, Your Honor, and if I could take Your Honor to perhaps I just want to take Your Honor to my letter. Sorry, may I take Your Honor to page 69 of the IGM report, 69 of the bundle.
All right.
Sorry, paragraph 3.2.1. This is not page 69. My apologies. This is at paragraph page 39 and 40. If I could take Your Honor to paragraph 3.2.4. This is I think they are outlining the next steps that they want to do in relation to Hodlnaut Hong Kong, which is to unwind DeFi positions held on decentralized exchanges and secure it with either in a cold wallet or in a third-party custodian account. If I could then perhaps take Your Honor to my letter. I think we've written to the IGMs regarding this. I think, and the point here I'm trying to make is that the conduct of the liquidation, be it liquidation, judicial management, these next steps, liquidating the Hong Kong assets, securing it in the cold wallet, these require somebody who is cognizant of the industry, understands the nuances, and is able to navigate this. Firstly, because if I can take Your Honor to paragraph 23 of the letter, this paragraph, this is my client's question to the IGMs for instructions on how they wish to unwind the DeFi positions, because it requires I think to give you some context is that they need to pay back a redemption fee in order to withdraw those assets. And to pay back the redemption fee, it needs to be paid back in stablecoin, of which Hong Kong does not have enough stablecoin. So that is so I think that's the tricky bit, which requires their instructions, what they're supposed to do. The second issue is that the residency issue hasn't been resolved. So it is a question of who is a creditor of Singapore and who is a creditor of Hong Kong, and whether in that case, whether there's a risk of ring fencing by the Hong Kong liquidator of the Hong Kong assets for Hong Kong creditors, and then leaving Hodlnaut Singapore as a creditor of Hong Kong. I think my point being is that there are issues. It's not that in appointing a liquidator is all these issues fall away. There's no required competence in the industry. It basically means it's the same submission that if no matter whether it's a judicial manager or a liquidator, they should have a minimum level of competence, which in my client's view is not there with with EY.
All right, thank you. Anything else, Mr. Pereira?
I think maybe one final point, one last sentence on the calculation in accordance. This is the ETH put. I think I took Your Honor to the section in the second IGN report. My only point here is that I wasn't making a submission as to a difference in the accounting views. I was just saying that they said that it should have been accounted for elsewhere and it would have gone into the accounts indirectly under profit and loss. And the point that I was making was that then if it does go into the accounts, why wasn't it shown in the table? That's basically it.
All right.
Unless Your Honor has any further questions.
All right, thank you, Mr. Pereira. Let me just have a minute. All right, thank you for your submissions. As I noted, whichever test is applied, and I don't think I need to choose between them today, I do find that the required threshold for the removal of the RGMs have not been met. The important thing I would note, and I would underline, is that the RGMs would not be held to the absolute duty or standard, and that leeway is given for judgment in evolving situations, then there is no requirement of perfect performance. I am not satisfied, despite the best efforts of Mr. Pereira, that cause on it, as he has expressed it, cause has been shown for removal, and it may be that other JMs or persons in charge would have taken a different tack or moved more rapidly, but that is not the requirement under the law. Now, whether or not there should be an order made by the court in respect of restoring losses to the company, I will leave open to another day. It suffices for me to just reiterate that the RGMs should not be removed. So that is my order in relation to this summons. Let me then return back to the question of the appointment of JMs. As I indicated, I have some concerns about this case based on the evidence before me, but I don't want to close things off for the company entirely. So going back to the course of action going forward, perhaps the best thing for me to do is to stipulate a date for the IJM to put into affidavit their assessment of the situation right now, and then invite the applicant, Ms. Ling, particularly your nominee, if he's willing, to put in an assessment of an affidavit of his views. And I would also give an opportunity to Mr. Pereira's client, Mr. Kang's client, or basically everyone, Sam Pinter, Algoran, to respond accordingly. But I just need to try to line things up. Ms. Yeo, when do you think you'll be able to file your affidavit, further affidavit?
Your Honor, I think you can file it in 3 weeks.
Bearing in mind, I note that CNY is coming up, but all right, with that in mind,
Your Honor, apologies, we didn't take into account Chinese New Year.
Yeah.
Maybe 4 weeks would be better.
4 weeks. Sorry. Okay, all right. Hold on. Wait. When are we? We are at that 1, 2. Maybe not as long as 4 weeks. Would the 3rd of February work?
Yes, Your Honor.
All right. IGM affidavit by the 3rd of February. Just capturing your assessment of the viability of meeting the statutory requirements. Response then, I think the primary one would be Mr. Lee as well as the company. For the company, Ms. Ning, how long do you think after the 3rd of February?
Your Honor, could we likewise have 3 weeks? This is because we'll have to liaise with our proposed nominee, and there's a fair substantial amount of documents that has been filed.
All right. This is on the assumption that he will want to. I note that you've not actually spoken to him about this, but could I also stipulate whether it's the nominee or someone else in the company that I assume if you don't get Mr. Tam, you'll get someone else in the company to put in the affidavit. All right, 24 February. So that works, sorry, 24 February for you. So that's for the company or the proposed nominee. Mr. Pereira, that good?
No, I won't take a different date. I'll take the same date.
The same date. And sorry, who else was there? Can I line everyone up on the same day, or do we need sequential? Mr. Kang, you're good for 24th?
Yes, Your Honor.
Mr. Ang, Mr. Chan, sorry, Ms. Pereira, Mr. Chan, you're good as well, 24th?
Yes, Your Honor.
All right, everyone else line up for the 24th. So I'll just note everyone else. All right. And I don't think it's necessary for the IGM to respond. I think if everyone just puts in the affidavits, I assume that we'll be able to take arguments thereafter. Do you think you need an affidavit reply, Ms. Yeo?
Yes, Your Honor, we would appreciate being
Right,
granted leave to respond.
All right, the main aim is to make sure that we don't delay unnecessarily. So if it's the 24th, 10th of March, Mr. Yeo?
Yes, Your Honor.
Your
Honor, if I could please clarify, for the leave that's granted to the creditors to file an affidavit, is it to all the creditors of the company, or is it only
no,
to
just everyone here. Everyone here. I don't expect to see any other affidavits. All right. All right. For Mr. Sorry, was it Mr. Sorry, I forgot. Mr. Marin, was it? Are you still there? Yes. All right. You don't have to file an affidavit. You can, if you wish to, you can come back at the next hearing and just state a position. So you don't have to worry about filing any affidavit. All right. Thank you. All right. So response affidavit by the 10th of March. And let's line up a hearing to be fixed by the registry in about 2 weeks thereafter. All right. So everyone is clear. So IJMs will file the affidavit 3rd Feb, 24th Feb. All the other stakeholders, creditors, and other interested parties present today, 24th of February, and response by the IGMs on the 10th of March, when we'll have a hearing about 2 weeks thereafter, so on a date to be fixed by the registry. And hopefully I can make a decision one way or another. So I'm giving everyone a chance to fortify their positions, but I will need to make a call at that point. One issue I would like to underline is that I would not generally be in favor of very long judicial management orders. I don't see that the function of the judicial management is really to stretch things out over a long period of time. I appreciate that sometimes commercial circumstances will require a bit of patience, but that I don't think is where a JM comes in. So Insofar as the viability of any plan is concerned, I would just like to flag that I will take a lot of convincing to contemplate a judicial management order being in place for something as long as 2 years. All right, so I'm open to being convinced, but I think there will have to be something fairly strong. I would see a judicial management as moving at a fairly good clip within 6 months to a year, perhaps, and anything longer will require a bit of convincing. All right, so I'd be grateful if everyone could bear that in mind. All right, anything else anyone would like to raise? If not,
I'm sorry, Your Honor. I just had to raise the issue because I think of not just summons 3660, but there were 2 other summons Your Honor had dealt with at the last hearing on cost.
Yes. All right, so given my orders, could I trouble the IJM then to file, to send in a letter arguing your position, stating your position on cost?
Yes, Your Honor.
Presumably against Mr. Pereira's clients. How long do you need for the letter to come in?
Your Honor, could I be so bold as ask for a week?
1 week, which would bring us, sorry, hold on. 20th of February, just before Chinese New Year. Mr. Pereira, how long do you think you'll need to respond by letter? I'll take into account Chinese New Year, but what do you think?
I would ask for a week, but take into account Chinese New Year, a week and a half.
Yeah, I'll give you to 27th.
Your Honor, 27th would be a week, right?
Oh, sorry, no, oh, sorry, oh, my mistake, sorry, a third, yes.
I'll be great for that.
Response by the 3rd of March and final reply by the IJMs by the 10th of March, and I will give my determination thereafter by letter. All right, to the parties.
Yes, Your Honor. I think it would it be 3rd February?
Oh, sorry, my mistake. I'm just being reminded. Yes. Sorry, IJM determining letter on cost in 1 week by the 20th of January.
January, Your Honor, yes.
Sorry, and response by the 3rd of February. IJM's reply by the 10th of February, and I'll give determination by letter otherwise. All right?
Yes, Your Honor. Most grateful, Your Honor.
All right. All right, then I hope I haven't specified a page limit. I hope both sides will be reasonable in terms of the length.
Yes, Your Honor, certainly. Grateful,
All
Your
right.
Honor.
All right. Anything else outstanding at this point? Everyone is clear about the directions. And sorry, what did I give in terms of the summons 41010 adjourn 4 weeks? Shall I just adjourn it to the next hearing in March?
Yes, Your Honor, I think that would be sensible.
Mr. Pereira, you're good with that as well?
Yes, Your Honor. Possibly we won't even have a hearing.
Yes, all right. Summons 41010 adjourn to next hearing as well. All right?
Yes, Your Honor.
All right, then. Nothing further. Thank you, everyone. I will see you later in March. All right. Thank you. Good day.
Thank you, Your Honor. Good day.
Good day. Court is adjourned.
Good day, Your Honor.
Good day.
Court is adjourned.